need to file a file an application under section 20.
File an application,
Section 24.
section 24. Yes,
My lord, difficulty is the
file the application.
no, my lord, difficulty is the department asking for the kind leave of your lordship.
Why?
Actually, my lord, the petitioner is the resident under the jurisdiction of principal bench, and the husband initiated the proceeding from Jalpai. My lord, she is the mother of two children, minor children, out of which one is natal. My lord, it is not possible for her to go to Jalpaiguri to contest the proceeding. If you lordship, kindly, I beg to your lordship,
Where the proceeding is pending.
Jalpaiguri.
But for transfer, you have to apply before the Jalpaiguri bench, circuit bench.
The Jalpaiguri bench, circuit bench is not there.
From Monday, it will be available.
Your lordship, kindly, my lord, kindly
Please
appreciate,
file on Monday.
my lord, kindly appreciate one thing. My lord, our lady.
Even if it is filed, it has to be transferred to the Jalpaiguri bench. File before the.
I'll online, I'll do this matter, my lord. If your lordship kindly do that.
No,
My
no,
lord,
no.
If your lordship kindly do that. My lord, please.
Please
Lord,
file
you are-
there. Yes,
I'm praying with your lordship. My lord, kindly appreciate this thing.
please file there because
The
that is
mother of two minor child. my
Maybe.
children. My lord,
Yes.
kindly appreciate this.
Lord, your lordship will permit me to.
To
where she is residing. Where she is residing.
Baguyhat.
She is residing at Baguyati.
Well, if you also kindly transfer this case to Honorable Circuit Bench, I'm not saying so, my lord. Let it be transferred. But my lord, kindly.
Come at 2 p.m. Let me see. Yes.
Yes.
Yes, call the list.
My lord, may I have your lordship's kind leave to mention a matter, my lord?
Yes.
Virtually. My lord,
Yes, Mr.
lordship's kind
Banerjee.
leave to mention a matter virtually.
Yes.
There's a matter where I would be seeking your lordship's indulgence to file without the certified copy, my lord. Because
What is
I'm
the
challenging.
urgency?
But the urgency is that I have been disallowed from participating in a sale process that's been conducted by the learned presiding officer at Recovery Tribunal. With a
Yes.
one-line order, I've been rejected. The 50% of it has been directed to be deposited by the learned presiding officer. The remaining for 50% is going to be direct. But the difficulty is that because I'm not a party to the proceeding, I will not be given a certified copy at all. This we pleaded in the application.
So do you have a server copy?
We have a server copy of the order. Yes, my lord.
Yes, leave to file without the certified copy.
My lord, one more indulgence, if I may pray for. Sorry, could it appear on Monday, my lord?
কবে থাকবে? Monday.
Monday or Tuesday will also do. Monday or Tuesday, my lord.
Tuesday is the combined list. Wednesday it will appear.
My lord.
Yes.
Grateful to you, lordship.
All the list.
Lordship, I appear for the opposite party.
Since I am not inclined to take up this matter on personal ground,
My lord, I'm for the petitioner. Your lordship, before elevation, was engaged as counsel in the matter.
since I am not inclined to take up this matter. Three same order released. Next. 4 same order released. Yes.
My lord, may I hand up the copy of the order? Oh, it's already there on record. So,
Yes. What
a
is the
small
correction?
little correction, my lord. Page 3.
Page 3, yes.
My lord, this is the third paragraph. This will be line 14 from the top. The sentence starts.
Yes.
My lord, that, my lord, if I am not mistaken, had stated that there should be in the second last line. That it's can be. I believe it's supposed to be cannot be.
That cannot be a ground
Yes.
for allowing.
Yes.
Uh,
The not has not come. My
Awesome.
lord had dictated, if I'm not mistaken.
uh, this matter has been mentioned for correct.
My lord, I'm appearing for the petitioner. My lord, this is a contempt application. On the last occasion, your lordship had directed the petitioners to make a fresh notice upon the alleged contempt, your lordship. I have made it,
Yes.
your lordship.
Item 5 ওইটা আমার item 5
A rule had been issued, my lord, but subsequent to a change of date, your lordship had directed us to file a fresh notice upon the alleged contempt,
Yes, you have served.
lordship.
আসুন। Next.
For the petition.
My lord, Mr. Amit Barandas appearing on behalf of the opposite party, my lord. I am praying for short passover, my lord.
Item number 7.
Yes.
Yes. Who is appearing?
Amit Barandas.
Yes.
The affidavit of service. My lord.
Yes, Mr. Mukherjee, entry order expired in November 2024.
Thereafter, my lord, I tried, my lord, but could not able to.
Since the entry order.
Kindly fixes, my lord.
I will fix the matter for hearing.
My lord, track to
I am fixing the matter for hearing. In
the affidavit of service be kept.
every service filed in court today is taken on record. Yes, next.
8.
None appears for the petitioner at the time of
Your Lordship, I beg to appear on behalf of the petitioner. I beg to appear on behalf of the petitioner, my lord. My lord,
yes.
there is a bona fide mistake. Two of the plaintiffs were asked earlier, they were supposed to be joined as petitioners, but since they were not present at the time of affirming, so their names were deleted by the learned advocate on record.
Deleted.
My lord, they may be added. That leave may be granted. And my lord, the matter is for expedited disposal of a eviction
Uh,
suit.
As paid for by the learned advocate.
Petitioner, my lord.
Yes.
My lord, there's a civil suit, my lord, which is pending, my lord, before the second court in Chinsura, my lord. My lord, this is my mercy petition before your lordship, my lord, for transfer of the civil suit, my lord, from Chinsura court to Bardwan court, my lord.
At what stage?
My lord, this is cross-examination is going on, my lord.
Cross-
My lord, my client, my lord, he's a senior citizen, my lord, he's visually handicapped,
Mm.
my lord, and he needs.
No, till this time you could
My lord,
proceed with the.
previously, my lord, he was in Hooghly, my lord.
No, no, no.
Now
It will
it's changed.
get delayed. It's you are the plaintiff.
I'm for the, yes, my lord.
You are deposing as PW1.
Yes, my lord.
So I'm directing the PW1. What is the next date fixed for PW1?
Next date is, my lord, 22nd, my lord.
I will direct the cross examination to be concluded on that
My
day.
lord, my lord, my client, my lord, he has changed his place of residence from Hooghly to
That
Bardwan.
cannot be a ground
That's
for
my-
transfer. That cannot be a ground for transfer.
Information demonstrated by the opposition.
Already you can serve but no stay.
My lord, kindly transfer, my lord. My lord,
Sir, at
he's
this
visually
stage,
handicapped, my lord.
at this advanced stage, no. At this advanced stage, no.
But only I was praying for, my lord, he was a
That
senior
cannot be a
citizen.
ground. That you have changed residence. You are the
Rather-
plaintiff.
My lord, he cannot attend.
Madam, you are the plaintiff. The jurisdiction does not depend upon the residence of the plaintiff.
Lordship, my lord. It is only for your lordship to consider, my lord, because it is 96 kilometers from Bardwan to
Maybe,
Chinsura.
maybe
Is 32.
I can only direct that on the next date, your cross-examination,
30 to
your
1.
cross-examination will be completed on the next date. What is the next date? 22nd of April.
22nd
I will
April.
direct that cross-examination to be completed on that date and the suit to be proceeded with.
My lord, I,
Get for a moment. Malu, kindly come to page number 33, my. He's visually handicapped, man.
All right, petitioner is directed to stay. Petitioner is directed to serve a copy of this application.
hearing of the cross-examination, my lord, your lordship.
That you said, told you, I gave you that opportunity, you did not avail. So if you say transfer, you don't want, I will direct the cross-examination to be concluded on that date.
After that.
I gave you that opportunity first. File
Consider the subsection 2.
Sir, if you want, I can direct, I have directed service. If you want cross-examination to be concluded, I can only direct that, but no entry order at this stage. Choice is yours.
Lordship,
Yes.
much obliged.
ঠিক আছে. Yes, call the next matter. Yes, 11, who is appearing? You are appearing. 11, you are appearing. None appears for the petitioner at the time of call.
This is for directing the court below to dispose of my eviction suit. Suit is on the ground of 2G.
Mr. Gupta, you are still moving expeditious hearing matters.
After a long time. 2G.
You are not allowing your juniors to move these expeditious hearing matters.
I should allow actually nobody.
Yes, what is the stage of the,
Peremptory hearing, Willard. It appears that it is at the stage of peremptory.
what is the nature of the suit?
Eviction suit under 2G and reasonable requirement, because 2G they do not have defense. And page 5, the suit was fixed on 6/5/2025 for peremptory hearing by order dated 18th January 2024. Therefore,
So you prayed for withdrawal of the suit.
it was, my lord, abandoned because there was
4th of January 2024, you thought of withdrawing the suit.
there was a compromise that they will leave. But
This
thereafter
application,
said
this
that
application under Article 2
Same matter, my lord, only title suit would be 13. Two suits,
Dates are same.
same. Only suit
Title suit-
number would be 13.
Suit number টা change হয়ে যাবে same order. Next.
আর ওটা 13
The
of
date for peremptory hearing is also the same.
13 of 2020.
Yes, next.
My lord,
Yes.
14 evict appear for the petitioner. My lord, hearing the title suit was filed, my lord, in the year 2012, my lord, 13 long years back, my lord. It is just prolong the hearing, my lord,
What is
prolong,
the stage of the suit?
my lord, from the order I just,
Revised plaint.
yes. 2019, the person who filed the suit, my lord, he passed away. Thereafter, his wife and daughter joined the suit, my lord. Though there is an injunction order, but that has been not duly
You
complied
did not
with.
on earlier occasions, you did not take steps.
Yes,
Suit
I'm
would have
not,
been-
I'm not for
Would have
that.
been dismissed for default in 2022 itself.
20?
22, 21st of September 2022. You did not take any steps. Show cause was directed.
Yes, yes. My lord, there are certain times for the unnecessary adjournment. There are certain times for the
So-
resolutions and etc. My
Show
lord.
cause was directed.
Yes, this is on one.
Time to file show cause even.
This is on
Your conduct for which this
this
suit is continuing from
this is
2012.
this is on one occasion. What I'm only
Not on all occasions.
what
You
I'm
did not
saying,
appear. Show cause. Then again time petition. Not show cause.
what I have been instructed, my lord, but this
No records.
Yes, yes,
Instructions
yes, yes.
cannot improve the
Yes,
record.
yes, yes, my lord. But I, as a council, I don't think that will be very good to say all this. But
This
my lord,
application-
kindly expedite the thing, unnecessary adjournment.
This application under Article 2. Yes.
Grateful one.
My lord, I am for petition order. My lord, this matter against the misappeal order dated 16/7/2024, my lord, whereby my lord in section 5 application has been rejected, my lord, and appeal has been dismissed.
What is the appeal?
My lord, appeal for the restoration of the suit. Against that, my lord, a miss case has been filed, that is on miss case 26/11. That was dismissed on 26th August 2022, my lord.
Do you think that this section 5 is to be allowed?
My lord,
I'm asking you as an officer of the court.
my lord, what happened, my lord,
Suit dismissed for default.
my lord,
Thereafter restoration application, that was also dismissed for default.
my lord.
Then another miss case for restoration of that
My lord,
restoration.
my lord, miss.
That was also dismissed.
My lord, with the unfortunate lady, my lord, he is suffering from the ailments, my lord, different type of ailments. And my lord, at that
What is the nature of the suit?
nature of the suit, declaration and consequential relief. My
What is
lord.
the declaration you have sought for? Where is the plaint?
My lord, plain condition is very bad, my lord. And my lord, I have asked for the certified copies, my lord. That has not been.
Conduct is very bad. You are not.
My lord,
free to-
my lord, I cannot prove my case, my lord. What happened? This is the, my lord, third plaint, my lord. The copy, because the original advocate has died, my lord.
So you also, even if it is restored, you cannot proceed with the suit.
No, no, I have,
Also should not be entertained.
my lord, kindly appreciate, my lord, the unfortunate lady, my lord. He has no capacity, and by the legal aid.
The order impugned, the application under section
My lord, I'm praying for an accommodation, my lord. Let the matter be adjourned for today.
Let the matter be.
My lord, I'm praying for an adjournment, my lord.
Why?
My lord, Mr. Utya Roy is the advocate. Mr. Utya Roy is the advocate for the petitioner. He
Sir,
could not,
Uttiyorai.
my lord, he could not come to court today. My
All
lord.
right, nothing I have seen. Short consideration, Supreme Court has decided. You are here,
My lord, I am not briefed in this matter. I know nothing about the case.
go through the file. You appear along with Mr. Uttiyorai in some matters. দিয়ে দিন।
My lord, kindly,
Cover.
kindly,
Yes, next.
kindly take it not today, my lord.
There is nothing. After Barasat High Hospital, short consideration. Fileটা দিন, উনি দেখে নেবেন। Yes, pass over. Next.
But I appear for the petition. But kindly comes to page 89. But page 89 is the order passed by this court, my lord, in an earlier divisional application. Now, my lord, the husband, but I am the wife in a, my lord, wife respondent in a suit for nullity of marriage.
You are the wife.
Wife.
Yes.
Now, kindly comes to page 89.
What is the impugned order?
By impugned order, my lord, this amount of 3,60,000 has been deposited by the husband before the learned trial court. Now, my lord, what the Nazareth department has done is they have misplaced the challans. So, my lord, we made repeated applications before the trial court to direct the Nazareth department to trace out the original channels so that we can get the amount of 3,60,000.
Yes.
So, my lord, kindly see, my lord, two applications were, my lord, disposed of by the learned trial court by the order impugned. My lord, first,
What is the date of the order?
well, the date of the order is 6 July 23.
6 July 23.
Lordship. Now, my lord, thereafter, my lord, we were waiting because the Nazareth department was, my lord, not able to find out the original copy of the challan, so we were not able to get the amount. Now, my lord, we filed a petition. By this order impugned, the learned court has only directed a petition is allowed, withdraw it. My lord, despite, my lord, several directions, the learned court ought to have directed the Nazareth department to trace out the challan so that the wife can receive the amount. But nothing done. This is my limited prayer. Kindly sees, my lord, last portion of the order. It appears that another petition for withdrawal of the maintenance already deposited from the Nazareth department, Alipur, is pending for order. Since these are arrears of maintenance amount already deposited, the petition is allowed. But my lord, the trial court should have directed the Nazareth department. The issue is husband had deposited the amount. My lord, he had deposited it by way of a challan before the.
So the husband has
Yes,
deposited.
yes. Well, the Nazareth department says original challans are not traceable, so the amount cannot be disbursed. So, kindly seize my petition before the learned trial court.
Where is your petition?
Well, it kindly comes to page 94. Well, at page 94, when I stand corrected, it should be page 96. Oh, yeah, so you got it.
96.
No, my lord, I stand corrected. I stand corrected. First, my lord, kindly comes to Annexure E, page 89. This was the order of passed by this honorable court.
No, not the order. Where is that? Where is your application which was disposed of? This 151. No, prayer for withdrawal. Where is that application?
My lord, page 94.
94.
Lordship.
No, where have you stated that this is the Nazarat department is not giving? Here you paid for withdrawal, that was allowed.
Withdrawal.
So where is that, which statement which you are making here? I'm allowing you to make that application before the Law and Trial
It
Judge.
kindly comes to page,
So thus the facts which you are submitting, that has not been stated in the application. So
Lordship,
you made an innocuous prayer allowing you to withdraw, that has been directed.
my lord,
So make an application that Law and Trial Judge.
150, 115.
Yes.
Kindly comes to paragraph 4. That pursuant to the above prayer, the Court of the Learned Additional District and Sessions Judge, First Track Court Number 7 at Alipur, was inter alia pleased to direct the opposite party husband to produce the copy of the said challan as on 17 January 2020. Consequently, it will be evident from the
No,
record
that was done. There is
that was
no-
done.
Yes.
Kindly comes to the next.
To
Right.
permit the petitioner to withdraw.
But kindly comes to the next paragraph, 116, that
Yes.
quite surprisingly, even after filing of the aforesaid above referred challans in Xerox form, till date the respondent has not
What
been-
happened to this application?
My lord, this is the order which has been passed by
You
the,
said 94.
no,
Now
my
you
lord,
are-
I stand corrected, it should be 150. My lord, this was my petition which the learned trial court had disposed of on that day, 17th March 21 petition. Now, my lord,
Uh, the
18.
My lord, item 89 for the petitioner, my lord, before your lordship. My lord, I filed this, my lord, this application, my lord, against my lord, order dated 13th September of 2024, passed by 12th ADJ, district, my lord, Alipur. My lord, I annexing the page, my lord, order copy after my lord, 404, my lord, in volume 3. My lord, the petitioner, my lord, filed the, my lord, title suit for forging and tampering the, my lord, their signature and creating the false deed. My lord, he, my lord, filed my move an application under order 39, rule 1 and 2, and praying ad interim order. My lord, the learned, my lord, trial court, my lord, refused the, my lord, ad interim order. Therefore, my lord, he filed the misapplication. My lord, the district judge, my lord, allowing the ad interim order on, my lord, 12th June of 2024. Thereafter, my lord, the file is transferred to the, my lord, 12th ADJ. My lord, that on the day, my lord, 13th September 2024, in Alipur court, they have a resolution. My lord, and on the said day, my lord, the opposite party respondent on the said day, my lord, they are filing the written statement and, my lord, other as well as document. My lord, that therefore, my lord, for bunch of document, my lord, the petitioner, my lord, praying only, my lord, 1 day accommodation for adjourning, my lord, for resolution, and, my lord, for, my lord, filing the reply without giving any opportunity, my lord, third soul, my lord, vacating the ad interim.
What is
order,
the date fixed for hearing of the temporary injunction application?
My lord, before learned court.
Trial
Ma-
judge,
Trial
yes.
judge, my lord, 24th April 2025.
So I'm directing the injunction application to be disposed of. This is ad interim.
My lord, in the meantime, kindly, my lord, rest. And my lord, kindly, my lord, short. Because, my lord,
Why?
because, my lord, the
1 month you cannot wait.
my lord,
For 5 months you could wait from September. 1 month you cannot
my lord,
wait.
only 1 month, kindly, my lord. Only 1 month give, my lord, interim protection. Only 1 month.
4 months you are without any interim order. That is the ground not to pass an ad interim order.
My lord, during, my lord, holiday, and, my lord, that's why, my lord.
What
slowly, that this is a default, item number 12.
Wait. Yes.
And if Lord, I am for the petition. Lord, one succession certificate, Lord, was granted in favor of the petitioner for 2 bank accounts and 1 locker of predeceased brother. Then, Lord, when I got the succession certificate, I went before the bank. They gave me the money in the 2 accounts, but did not allow me to handle the materials inside the locker because it is an inadvertent mistake on my part, Lord, in pendency of the said succession case. I inadvertently did not file the.
Who are you?
I am the brother of the deceased who had these 2 accounts and locker in that said branch.
Who are contesting this proceeding?
No one.
No one is contesting.
No. No, I prayed for a succession certificate. Now, my lord, I inadvertently.
No one is, all are brothers.
All are brothers. Inventory commission was not done, my lord. That is why the money of the 2 accounts is given to me, but the locker is not allowed to be handled by me. My lord, that's what I prayed before the learned judge to kindly allow me to do the inventory commissioner work. That is rejected, and learned judge directed that the petitioner.
Where is the succession certificate? Where is the succession certificate?
Page number 19.
19.
19. Lord, learned judge by the impugner directed to file fresh suit for law. The item number C, locker.
The petitioner is directed to serve a copy of this application upon
Lordship, I am appealing on behalf of the petitioner in this matter. I am praying for expedite disposal of the suit. The suit is filed on the 18th of April 2016, and now the plaintiff petitioner is aged about 87 years. But the
what is the stage of the suit?
Actually, the suit was dismissed on 21st April, March of 2017 due to the demise of the plaintiff. The plaintiff is unable to take steps before the court, and thereafter the suit was restored by the miscase filed by the petitioner plaintiff, and now the suit is in the stage of PH board, but the defendant after
Madam, you are directed to show cause by order dated
in my prayer B and prayer A,
by the order dated 16th of August.
that is
You are
last
directed
order.
to show cause by 20th of November as last chance.
Yes.
So if your show cause is not accepted,
No,
suit goes.
I am not the defendant. I am the plaintiff. I am the plaintiff in the suit. I am not directed to file show cause. It is upon the defendant.
You are the plaintiff.
Yes, I am the plaintiff. because the suit is for 2016 and my
If you
plaintiff.
text us diligently, it will be disposed of expeditiously. Yes, next.
So, dear my lord, I am appealing for the petitioner.
Yes.
The preemptor is the petitioner before your lordship. This application under section 8 of the
Preemptor is the petitioner.
before your lordship. So, application dismissed is that appeal was preferred. In the appellate court, the opposite party is
Preemption application dismissed.
yes. Appeal preferred, miscellaneous appeal preferred.
What consideration, Mr. Rai? Part by limitation?
No, it is not that.
On what ground it was dismissed? Preemption application was dismissed on what
There is
ground?
some other ground.
What is the ground I am asking you?
I don't know. It was dismissed. Here, my lord, the recording of abatement.
That I follow. So recording of abatement. So you will not text us why it will not be recorded as
There is no other years are already on record. I mentioned
other years already on record.
That is why my lord can turn to page 13. And 15.
13 and 15.
Yes. After that, an application was filed, page 17.
So respondent number 6 died.
Yes. Now one can turn to page 19.
Yes.
That Sri Joydev died bachelor, respondent 1 to it.
Living behind 1 and 2 as legal heirs.
Yes. The respondent 3 died living behind, the respondent 1 to as legal heirs, died bachelor. As the above facts, because the respondent 6, 1 and 2 are all the same.
So what did the appeal court say?
Manor can turn to the order impugned 20th February 2024.
My lord, I am for the petitioner husband, my lord. This pertains to a maintenance proceeding under section 24 of Hindu Marriage Act, my lord. My lord, I am presently jobless, and after I lost my job, my wife voluntarily deserted me. Thereafter, I had to file a restitution proceeding and also an application under section 7 of Guardians and Wards Act. And thereafter, I was given, I was allowed to meet my child, my lord. Thereafter, I am presently jobless, and I am already paying voluntary contribution, and that is annexed at page number.
What is the amount which you are paying?
My lord, I was paying 4,000 towards the child, my lord, and I am directed to pay 15,000, my lord. But I am jobless, and she is also she is earning, my lord, around 20,000 per month.
That, what is the finding of the learned trial judge? That may be your allegation, but whether you could, how she is earning?
My lord, she is getting rent from her house, which she has not
What is the
disclosed.
document you have produced?
My lord, I couldn't produce
So-
documents, my lord. But
So
my lord,
even
I
if
am,
you are jobless, you have to maintain your
yes, my lord.
wife and the
My
daughter.
lord, I was making voluntary contributions, my lord, and it is there. I have already annexed it, my lord.
That is neither here nor
And my
there.
lord, the wife has already admitted it in the main application only.
What?
That I am jobless, and that's why she
Show me that.
deserted. My lord, at paragraph number 4 and 5.
Page.
Yes, my lord, which is page 24, my lord.
Yes.
Sorry, 25, my lord. Page, paragraph number 4 and 5.
Yes, where she has admitted that you are jobless.
My lord, kindly comes to the last line of paragraph 4.
Yes, yes.
And
Place the last part of that sentence.
yes, my lord, I left the job, and thereafter kindly produce the affidavit of assets and liabilities filed by the wife, my
Madam,
lord.
kindly place the last part of that after and. You are placing paragraph 4 last line. So place after and.
My lord, that is what I was saying, my lord.
He runs his business as an
My
astrologer.
lord,
That is the difference. So you have said that she has admitted that you are jobless.
my lord, I left my according.
Maybe for a who, when does a person leave a job?
My lord, I did not
When
leave my
when
job.
he or
I
she
had,
secures a better.
no, my lord, I was working in
So you're
Mumbai. I
finding
lost
as
my
equal.
job, my lord. There's no, my lord, there's nothing annexed in the affidavit of
Where is
assets
your
and
affidavit of assets?
liabilities. At page number. At page number, my lord, 36.
36, yes.
It is my assets and liabilities, and in her assets of liabilities at page 44, she had said that I'm earning around 2 lakhs as an
Yes.
astrologer, but not working as like I lost my previous job also, my lord.
Maybe.
I'm not earning anything as an astrologer, my lord. There's
You have
nothing
to
annexed
pay.
to it.
This application under Article 227 of
My lord, the petitioner are the tenant under the opposite party, and thereafter the opposite party filed.
I came to know from the court below that they have filed this application and for the opposite party plaintiff there. You have not got a copy? No. Give him a copy.
No.
What is this matter? Let me see.
The matter is, my lord, the original defendant filed one section 151 of the CPC for repairing of the suit premises. Thereafter, that application was rejected, and thereafter the original defendant expired and the substituted by the legal heirs of the original defendant. And thereafter, the substituted defendant also filed the same application, Order 39, Rule 7, along with the section 151 of the CPC for repairing of the suit premises.
Same application bought by res judicata.
My lord, the condition of the suit premises is not.
Maybe, but the earlier application was rejected.
My lord,
You did not challenge that order.
that case, I want to refer one judgment of the apex court that if the new the court would competent to make.
What is the subsequent, what is the change of circumstance?
My lord, the suit premises is very much dilapidated and it is not.
That was also there in the earlier
My lord,
stage.
it is it's after 10 years, the situation is more worse.
Show me that, that is your ground taken in the application. So, if that is so, it's barred by res judicata.
My lord, it is 10 years.
I accept your submission that if there is a change of circumstance, the principles will not apply. But show me that you have made out that case. The earlier, when the earlier application for repairing was rejected,
Yes, my lord.
did you pray for commission work
Yes, my lord. In the second application.
in the earlier stage?
My lord, that's.
Commission work, you did not pray. Now you have prayed for commission work. What happened to that?
That was rejected.
That was also rejected. Do you have a copy of the rejection, earlier order of rejection of the repairing application?
Annex.
Page.
My lord, page 48,
48.
50, my lord. 48 it starts. My lord, it's typed on the page 6 of my petition.
Type copy is that page?
6 of my petition.
Only 6.
Only 6.
That is in the.
Oh, you have mentioned that order. Photograph. What I will do with the photograph, sir, from here? ফেরত দিয়ে দিন. কোন বাড়ির photograph কেউ জানে না.
The actual tenant died long back. Thereafter, this person have occupied.
So then you are ready with the matter.
No.
That will be decided upon the fate of the suit.
Last consider.
Where is your application for repairing?
My lord, present application.
Present application.
Page 54.
Page
54.
67. Where is your application for local inspection?
My lord, 54.
54.
54.
Yes. What do you say?
But so far, I have obtained some copy today only. But
One time.
I want a bit
Look,
time.
yes, I can give you time. Only one thing. The earlier application was rejected.
Yes.
Yes, ma'am.
So, but at that point of time, no local inspection application was, no prayer for local inspection was made. So after all, it's your property.
Yes,
So it's what is the suit for? Eviction. Eviction. So after all, it's your property. So now they want to replace only the, kindly come to page 69, the nature of the repairing work which they want to do. Only the broken tiles, this bamboo frame, and to repair the damaged floor and walls.
Yes, my lord.
So let the inspection be made.
Yes, my lord.
If the inspection report, the commissioner says no repairing is needed, it will be done. Otherwise, if this is bamboo frame, it falls down, it will cause injury.
Yes, my lord.
So this is the only thing. If you want time to go through this, I can give you time, or otherwise I can direct only allow these application, and after that the trial court shall consider the application for repairing.
Yes, my lord. That is better. My lord, the local inspection can be done.
My lord. Agreed.
Yes.
Yes. By the order impugned, the application
Since then, there was no toilet and washroom. After getting the property lordship, petitioner decided to set up the toilet and washroom lordship. What happened, lordship? Order 39 rule 4 application.
Order 39 rule 4 has
Four
been
app-
rejected.
That was rejected.
So appellable order.
Now, first time it was
Sir,
appealed
by
because-
this order impugned, order 39 rule 4 has been rejected.
This is the second time rejected, lordship. Due to that,
First time, second time, order 39 rule 4 rejection is an appellable order under order 43 rule 1R.
yes, this is applicable.
So, by the order, by the order
My lord, I am for the petitioner. My lord, the impugned order, my lord, is a rejection of order 9 rule 7 application, my lord. My lord, this is a match suit. I am the respondent wife. Now, my lord, on the very first date after service of summons, I was out of station, therefore I was not able to appear. On the next date, my lord,
where is your explanation? Order 9 rule 7?
my lord, the application itself is attached and also in the petition, my lord.
Petition will not help. Show me from the application. What is the ground stated?
My lord, she was out of station
From
from the 3rd of January to, my lord, page 18, my lord, the application.
To 16th of January.
16th of January.
When did you receive summons?
Summons was received on the 7th, my lord. 7th of January.
Who received that?
My lord, the mother. The mother of.
Where have you stated that?
My lord, in the application.
Show me which paragraph you have stated that.
My lord, in the application, my lord, she has not stated that, my lord.
So, it shows that you received the summons.
No, my lord, she was out of station, my lord.
What is the document you have produced to show that she was out of station? No statement, only by making a statement when the summons was served. And who has received, you have not deliberately stated in this application.
I have just shown the cause,
This
my lord,
type of
just for
applications are to be drafted very carefully. Not in this manner.
it was served on the 7th, my lord. It was served on the 7th.
Who received?
But received by the mother, that has not been specifically pleaded in the application. But in my petition, I have stated, my lord.
Petition, you cannot improve your case by making statements in the, because the court has considered this application. Court did not have the occasion to consider this application.
And just, my lord, at the very threshold of the suit, my lord, on the very first date, and this is the second date when I have appeared, and I have filed this application.
Time to file written statement has also gone.
No, my lord, it has not gone.
30 days has not expired.
30 days has
So,
gone. So therefore, my lord, I have also made an.
You have a right
that
for an extended period.
I have also.
You have a right for an extended period.
No, my lord, but I have prayed. I have made an application in
90 days has also gone.
No, 90 days has not yet gone, my lord. But today also 90 days has not gone, my lord.
Today 90 days has not gone.
7th January, my lord.
My lord, I appear for the petition.
Yes.
My lord, the petitioner is a plaintiff, my lord, in a probate proceedings. My lord, the petitioner is aggrieved, my lord, by the order dated 17th of December 2024, passed by the learned 13th edition.
What is the challenge? Which order?
My last order, my lord, last page.
17th of December 2020. Yes.
My lord. By this order, my lord, the evidence on behalf of the plaintiff was closed. And it was closed on the basis of earlier two orders, my lord, without considering the all other orders. And it was misinterpreted. My lord, I have also annexed those orders.
What is the nature of this proceeding? What is this proceeding?
My lord, this is a probate proceedings, my lord.
Who are you?
My lord, I am the beneficiary of the will, sole beneficiary.
You are the propounder.
My lord,
you have filed the application for
yes,
grant of probate.
Yes.
For
letter of administration.
Yes, for letters of administration.
My
So
lord.
now,
No, my lord, if your lordship.
how many witnesses you have?
Two. I have.
Two has been done.
Yes. One is left.
Only one is left.
My lord. Yes. Only one is left. That has been closed and date has been fixed on 11th
Rightly
for defense
closed.
witness. My lord.
Rightly closed.
My lord, if your lordship kindly sees the other previous orders, that is why I have annexed.
Yes, from order dated 30th of June 2023.
30th of.
Yes, you
No, no.
took time for bringing an interim order from this court. Next,
No, that is.
17th of July, time taken to bring an interim order from this court. 24th of August, you were directed to show cause
My lord.
as to why evidence will not be closed. And the date was fixed for filing show cause.
My lord, may I just.
13th of December.
Yes, cause was shown. It was
You
accepted.
have not taken any steps.
No, I have taken steps, my lord. Cause was shown, I was present. It was
Witnesses were not present.
My lord?
Witnesses of yours were not present.
No, there was a show cause, my lord.
Yes.
Cause
and
was shown.
Yes.
And
evidence. Kindly come to 24th of August, not only show cause. Showing cause and evidence on his behalf.
My lord.
So,
now, my lord, kindly.
So you only filed a show cause petition without bringing the.
No, my lord. I filed an application also, my lord, under 151, my lord.
Why did you not bring those witnesses on that date?
My lord, if
Order 16, Rule 1, capital A.
No, my lord, kindly see the next two orders also, my lord. Kindly.
Yes.
Kindly.
Yes.
Order number 29 and 30.
Yes.
My lord, the presiding officer was on leave. I am.
No, that is the.
No, that is not the.
The presiding officer will not appear.
No,
for that. Presiding officer was not available.
No, what I was pointing out, sir, only the last sentence. Only the last sentence.
Rightly rejected.
That.
So what is the ground for?
Well, I am only praying, my lord, that one witness is left, my lord. I may be permitted to.
Make an application before the learned trial judge.
My lord, I have already filed an application. That application is pending. Not for this, my lord. I have filed an application so that the specimen signature of the testator may be compared with the admitted signature. That application has been kept pending.
That civil division is pending.
That yes, that 151
Civil division is pending, and for that you took many times to obtain a stay order from this
not many times, my lord. Twice, my lord. Oh, this is my only prayer, my lord. Kindly give me one
Make
more
an
chance.
application, because this court cannot go. Why you did not file? Even you did not file any petition for adjournment.
My lord,
so the learned trial judge ought to have dismissed your application on that day. He was kind enough not to dismiss the application. You did not take any steps. You did not file any adjournment petition either.
No, the learned advocate.
You file an application before the learned trial judge. Why you could not bring on that date? If the learned trial judge is convinced.
The only thing, my lord, I should be fair to your lordship. Only on the last date, there was a not to attend resolution from 12:30. The matter was called on at 12. I filed a hajira in the morning.
These grounds. This court cannot decide that. So take all these grounds in the petition. I will give you that liberty. If you file an application, the learned trial judge will consider that. Because the learned trial judge will be in a best position. Whether there was any resolution from 12:30, 1:30, 10:30, I cannot decide those things.
It is there, my lord. It is. Well, I think I have annexed.
Mr. Mitro, this application, what you are stating, the reasons, I cannot decide that. You have to file an application there.
And my
I
lord,
cannot decide that here.
Very well, my lord. I will file the application. The only difficulty is that, my lord, the next date is on 11th.
So 11th, prior to that you file.
That is on 10th. 10th is the only date left, my lord.
Why? Today also you can file.
My lord.
Why? Has to. Otherwise it will be closed. Today you can file. Phone call your counterpart. He will draft 2-line application, file that. Tenth is also there.
The 10th. That is
Date
why I
is
said
till
I
11th.
10th is there.
So I'll give you liberty, file an application there.
And my lord, My lord, grateful. My lord.
Yes. Coming after 5 minutes. I could not come, it is dismissed for default. And 11, it is dismissed for default. I have knee pain, I could not come.
Yes, call the list. I am not the petitioner, my lord.
Yes.
This is an application against a rejection of an order 7 rule 11 application, my lord. My sole contention was there is no cause of actions and it is barred by law because
At what stage you have filed this application?
actually it is too late.
Let the suit be decided.
But it is too
All the issues, you have taken that in the written
No,
statement.
no, my lord. First of all, the matter.
No, you have
should
taken
not-
all those points in the written statement. So you will be entitled to urge all those in the time
No,
of hearing.
My first question is whether the suit is the sacrament. If
Suit is-
plaint is the sacrament document. If there is a clause,
I could not follow. I could not follow. What did you say?
the plaint itself is a document of sacrament document. Where if there is a clause, if there is some statement that this suit, I am prevented to make my name recorded. I was restrained to do that thing. It is in the record. So whether the application can be rejected or not, my lord, that is my question and nothing more.
Application can be rejected because since it's at the evidence stage, let the suit be decided. You will be entitled to raise all points.
My lord, wrongly it is continuing. Actually, on the latches.
I'm expediting the suit. I'm expediting the suit.
No,
What
no,
is the stage?
First of all,
What is the stage?
My lord-
PW1, cross of PW1.
yes.
So you do it fast.
No.
Sir, your hand now.
After that, the defendant number 1, I am defendant number 2. She has already died.
She is already
died. The suit is continuing.
Take the point of abatement, file an application, suit will be abated.
My lord, prior to that, this application we decided, my lord. Prior to this, whether my contentions it should be adjudged or not. Whether there is a if the suit is barred, if the suit itself is barred, can it be continued?
One thing.
It is late.
Now there is an issue framed with regard to the maintainability of the suit.
Yes.
So if I return any finding on that, that may affect your suit in that issue.
But
kindly consider that.
Actually, primary
Because maintainability is an issue.
Yes.
So if after hearing your submission, I return some finding on the maintainability issue, that may go either way. So I think since if you could have come at the early stage, it was there, but now at this stage.
So far my contention is that kindly have a look on the plaint, my lord. Have a look on the plaint. What is the plaint?
What are your grounds under Order 7 Rule
My
11?
lord?
What are your grounds under Order 7 Rule 11?
Two grounds. The cause
Yes.
of there is no cause of actions because it is pure.
Why there is no cause of action?
Because it is purely a matter which is related to land revenue codes, BLRO and others. And second point is that the law itself what to continue in a suit in a civil suit.
So it's a
Section
suit for-
51C, section
It's a
51.
suit for partition.
Yeah, suit. It is a very interesting matter, my lord. Where
It's a suit for partition. How do you say that there is a failure to disclose cause?
I am not. They are stating that I have no right. I purchased a property. My name is recorded.
That cannot be decided under Order 7 Rule 11. Whether you have a right or not, that has to be decided by trial on evidence.
My lord, one thing is to be decided. The provision is there. They have to
Which
make
provision? According to you, the suit is barred under law.
Under law.
Which provision of law under which it is barred? Show me that.
I am coming. Kindly. Please have a look on the plaint.
No, show me which provision the plaint is barred under which provision of law. First, show me that.
This suit is barred by section 51C of the Land Reform Act.
Yes.
And
51C.
section 14X of the Land Reform Act.
Land Reforms Act adin.
That is a very vital one, my lord.
Yes.
No suit can be continue in a civil court.
Yes.
Unnecessarily.
51C.
51C and
rules
14X.
টা দিলেন তো,
And
একটা
14X.
দিন। Land Reforms Act. You have Land Reforms Act আনেননি? Rules. Land Reforms Act. ওইদিকে আছে বোধহয় Land Reforms
My
Act.
lord, perhaps it is there. The last one.
Yes.
Section 14X and section 51C.
And 51C.
And 51C.
Yes. Show me from the prayers.
My lord,
Show me from the prayers in the plaint. Which prayer is barred?
kindly see. The first prayer preliminary decree of partition declaring that plaintiff has half share and defendant number 1 has half share over the suit property. And
That is not barred.
No.
Which prayer is
That-
barred?
that-
Show me.
The
Which prayer is barred under
I'm-
14X and
just-
51C?
just I'm coming on. The that D, a decree declaring that forcible possessors have had no saleable right.
No,
where
which page you are placing?
And subsequently the prayer, the
Yes.
decree declaring the sale deed.
So this is barred under section 51C.
51C.
Read with 14X. Read with 14X.
Yes.
Yes, next. This is one point. Next.
And E, the decree declaring that the sale deed for the year 2002 in the name of the defendant number 2 as well as the deed of Sheikh Sarabuddin are void, illegal and not binding upon the plaintiff defendant number 1. Finally, have a look on my record of rights. Record of rights is there.
Record of rights is a document of title, sir?
Yes, no,
Document of title.
no, mother. It is a document of positions. In the plaint, they have no position. They themselves claimed they have no position. So how can the property be divided?
A rebuttable presumption also. Also a rebuttable presumption. So it will be decided at the time of evidence.
Exactly, my lord.
So
But
not in order
when- when there is some documents, particularly in relation to possessions of the land in questions, primarily the civil court should not entertain it, my lord.
Anything more?
There is alternative.
Anything more?
No, my lord.
Thank you. Ashok. This application under Article 2
For the petition.
ওটা এক করে দিন however the
There is a caveat, my lord. आपने क्या?
caveat you have not served upon the caveator.
My lord. This is
What is the order under challenge?
what are against the
Right now, my lord. He's serving right now.
What is the order under challenge? Which order you are challenging?
injunction passed by the learned court, my lord.
Sir, it's an appellable order, sir.
My lord,
Order 39 rule 1 and 2. It's an appellable order.
against the injunction order, not against the defeated in injunction, my lord. My lord, this is the against injunction order.
It's not an appellable. Order 39 rule 1 and 2. Ad interim injunction. Ashun. This application under
My lord, suit for declaration permanent injunction, order 39 rule 1 along with order 39 rule 7, both rejected. My lord, misappeal filed, my lord, rejected there. My lord, from there, my lord, the impugned order, last page, my lord, the operative.
both ad interim refusal.
Both ad interim, the first refusal was on the ground of there was a caveat, my lord, which was not against us, my lord. The operative portion, my lord, in the last page, my lord, certified code. They use the documents, my lord, filed on behalf of the appellants available in the case.
You are out of possession.
Admitted. My lord, I don't want that, my lord. Simple thing, my lord, not to create third party right. My lord, this is constructing, my lord, a residential building there.
Construction made,
No, no, it's
started. Up to what stage?
My lord, first floor level, my lord.
Then
My lord, kindly, my lord, my
Yeah,
trees
it-
have been pulled down, my lord, cut, my lord.
at any
property-
time, it can be pulled down.
My
That
lord,
is
I
there.
understand.
And second thing is that whether you are entitled to injunction at this stage when you have allowed the construction to go up to that extent.
Yes, my lord, that I understand, my lord. But rule 7,
Interim cannot be granted.
rule 7 is also, my lord.
So rule 7, so let the report come thereafter.
7 disallowed, my lord.
So rule 7, there are two things. So if you say, I will consider your application for order 39 rule 7, I will direct issuance of notice only on that.
My lord,
If
kindly.
you want interim order on the application, no.
My lord, kindly then direct on rule 7, my lord. Kindly.
By the order impugned, the
Petitioner. My lord, I am for the plaintiff petitioner suit for declaration and injunction. My lord,
What is the order impugned?
order impugned is that, my lord, the defendants had filed a counter claim way after 2 years of expiry of the filing of the written statement. They had filed the written statement in the year 2022. Issue was framed. Thereafter, in the year 2024, they filed the counter claim. That too with the defective.
Is there any bar in filing a counter claim after the written statement?
No, no, my lord. The schedule itself is defective on which the counter claim has been allowed.
Schedule is defective.
Yes, my lord.
What is the schedule?
Kindly comes to page 27, my lord. Schedule.
Did you raise this point before the learned trial judge?
Yes.
How it has been dealt with? Show me that.
My lord, kindly comes to the order impugned, my lord.
Yes.
My lord, second paragraph.
Please use the microphone.
Yes, my lord. Second paragraph, my lord.
Page.
My lord, second last page of the
Penultimate page. Yes. Which paragraph?
Yes. Second paragraph. Now in this instance,
Yes.
my lord, 1, 2, 3, 4. From the fifth line, my lord.
But in the counterclaim, the defendant has introduced a new scheduled property.
B schedule counterclaim property, which is completely different from A and A1 scheduled property. In the counterclaim, my lord, they're referring to one A1 scheduled property, whereas there is no presence of any A scheduled property.
Yes, that has been excluded.
Yes, no, there is no presence of any A scheduled property. He is relying on the A scheduled property itself, my lord. There is no relevance of the A scheduled property in his counterclaim petition. So how come that counterclaim this be allowed on the A scheduled petition, my lord? That is what I'm trying.
Where is your plaint?
Yes, my lord. My plaint starts from page 14. My schedule, page 17, A scheduled property.
There's A1 at page 18.
Yes, but that is not the A1 that he is referring to.
A and N1, there are two schedules. That is what the learned trial judge has said.
He is referring to the A1 referred to by the defendant, my lord.
Where is, show me
Page
that
27,
counterclaim.
Page 27, my lord. Even he is claiming prayer over a plot number which is not in existence. Prayer number 3, my lord.
This is the same as A1 of your same property. What are you saying? This is the same as A1 of your property.
Yes, my lord. But
So it's not different. This application under
to
With a simple prayer, my lord, probate suit was filed in 2021, my lord. Till date,
Expeditious hearing. What is the stage of the suit?
my lord, I submitted the draft publication citation, my lord. It has, for verification, it is pending for long. My lord, the court is, my lord, lying vacant. The second court is in charge. My lord, second court is not inclined to take up the matter. My lord,
Charge court cannot decide a suit first. Second is draft publication is there. So the suit is not ready for hearing.
my lord,
At this stage,
by this process, my lord, it is being dragged.
not at this stage, come at the subsequent stage.
My lord, I am appearing for the caveator. My lord, I will be seeking only 1 week's time because certain,
1 week, why?
my lord, the next week, any date, my lord, because certain documents, including affidavit of assets and the counter affidavits and the opposition has not been, my lord, received from my client, my lord. He is
I'm
not
dismissing
all-
that.
All here. No, not all.
They're not dismissing, you have not annexed all
For my
papers.
affidavit of assets.
You have not annexed all papers. It's not
Let him
in
show
form.
my affidavit of assets. Lord, he has annexed his affidavit of assets. My lord, why?
And your affidavit of assets has not been annexed.
No.
Lord, may I just say this?
What you are trying to hide from his affidavit of assets?
No, that is not the subject matter of this.
Who are you?
Lord, I am the petitioner husband.
Husband, say so. Petitioner, I could appreciate. Yes. You want reduction of the alimony.
No, forget about reduction. Lord, I was not heard. I did not get an opportunity to cross-examine. I did not get any, Lord, opportunity to meet whatever the statements are. Lord, I'll show your lordship, Lord, 2-3 things. Thereafter, Lord, whatever praise my learned friend makes, Lord, I'll concede.
No, you are not given any opportunity of hearing means I could not follow.
Lord, on the 4th of January 2020, Lord, it appears from the records that on the 4th of January 2020, she filed her affidavit evidence in support of her miss case. Thereafter, Lord, from the records, it transpires that in the year 2024, Lord, the learned court below in the miss case passes an order saying that the evidence in chief in support of the miss case is not yet complete and fixed a particular date. The date was 26th of September 2024. On the 26th of September, she prays for an adjournment. The matter is fixed on the 27th of November. On the 27th of November, Milord, the certified copy is not available. Milord, we have taken, Milord, a photograph. We can show your lordship, Milord, what happened. The hearing is concluded and the matter is reserved for orders. And on the 16th of February 2025, Milord, an order is made by the learned court below, relying on, Milord, what we do not know, and holding that it is a presumption.
But you have filed your written notes of argument.
And after 7 years, I'm sorry.
In the written notes of arguments, we took the specific point that there was no opportunity to extend it to cross-examine the defendant wife. And Milord, she has a counterclaim for divorce.
No, that is the matrimonial suit. So here the parties have laid their evidence. They went to the.
He has laid her evidence. We did not.
You are not given any opportunity to cross-examine.
Nothing. Well, let him show that I was given an
if you have given.
Well, I'll show your lordship.
So, Mr. Kindly see. If you have given your evidence, he was not given any opportunity to cross-examine, then it is to be remanded on for that. Otherwise, it will be unnecessarily delayed here.
Well, I'll just show your lordship.
Just because I have got information from my client.
I don't know. Just a minute. দাদা এটা নাও আমি তোমাকে দেখিয়ে দিচ্ছি কাইন্ডলি সিজ না না তুমি দাদা দেখো না আই এম শোয়িং ইউর রেকর্ডস সার্টিফাইড কপি
The father
of the wife was one of the practicing
My
advocates.
lord, please see this.
I have a telephonic conversation. He was not well. That is the reason he could not supply me the papers. My lord, what he told me that
First of all, you blamed me.
Mr. Bhattacharya, allow him to submit.
after 7 years of filing of this matter, the order of alimony penalty right has been, my lord, order has been given by the learned trial court. My lord, I have already indicated the papers, my lord, including the counter affidavits and the affidavits of assets which we have filed. Your lordship kindly fix any date except 10th on the next week. My lord, I will come with all the instructions.
I just show your lordship, my lord, 2-3 pages. My lord, I've given a copy to Mr. Mitra. My lord, please see order number 114. Order number 114.
Page.
There.
There. You have given a copy to Mr.
Yes,
Mitra.
yes. Both sides filed Hajira.
114. Yes.
Now, this is order dated 24th of July 2024. But it appears from the record that the evidence of petitioner has not yet been completed after 4/1/2020. In such condition, case be fixed on 26/9 for evidence of the petitioner. Then, Vinod, please see the next date. Order number 116, 26 September 2024. Opposite party 27th of December, November. Opposite party files Hajira. Petitioner files one adjournment petition, praying for another date on the ground stated therein. Petitioner means in the missed case petition.
The wife.
Date allowed, wife. Case adjourned till 27th November. 27th November certified copy is not there. I am reading 27th November, order number 119. Both sides filed Hajira. The hearing of missed case pertaining to maintenance pendent life has already been concluded. This is what the learned court records.
Let me come with instructions.
This is the certified.
From the my lord, let me come with instructions.
My lord, if he can show that I was afforded an opportunity of hearing, I don't have a case, I go out.
Very well.
And on the basis of presumption, the learned court below derives a conclusion. The 27th November order.
Record shows.
Mr. Bhattacharya, 118, order number 118
My lord.
says both the sides are present, heard both sides at length to 18th of December as for orders, written argument if any in the meantime.
Yes, without giving an opportunity of cross-examination. And that point is specifically taken in the written notes. I can show your lordship here and now.
Well, then he has to file a supplementary affidavit indicating this order.
No, the written note.
Well,
The
this order
supplementary affidavit.
he is showing to your lordship is not annexed with his divisional
Mr. Bhattacharya, do you have a copy of the order number 117
No, I don't. The certified.
from this?
Yeah, it is there. It is there. Just.
দেখুন সাবধানে খুব দামি জিনিস
Raman. Well, I don't know. Paper. I do not even have a tab.
Your lordship kindly fix any date, my lord, I will come with that.
Very well.
All the instructions. And later copy of the order may be.
তোমাকে দিতাম তো ওইটাই তো
আরেকটা দেখাচ্ছি না।
27 নভেম্বরটা সার্টিফাইড কই পাচ্ছি না দাদা।
তোমার ওটাই পাঠিয়ে
ওখান
দাও।
থেকে আমি পাঠিয়ে দেবো।
You can download that from the website. It is available in the website. 117 is there. Show me.
টা নেই। Get 117. Everything is available now in the system. Not everything is uploaded. And my instruction is not every order is uploaded. 117 says.
Order is there.
Yes. এগুলো সব প্রিন্ট বের করো অনির্বাণ দাকে একটা কপি দাও বুঝতে পারলে
No.
আর তুমি
This is in the matrimonial suit.
Yes.
Yes, matrimonial nullity of divorce was filed by
27th of 27th of November. What is the order?
The next order, Milord, which I invite from the tab. From the tab, it is there. But I'll get copies, Milord, in that event.
27th is the earlier order, 118.
Yes.
Mr.
Hello,
Mitro,
let me check my.
prima facie it appears.
No. I'm not disputing without checking, Malo. It will not.
No, Milord, precipitate action be taken. In the meantime, Milord.
What precipitate action?
I am obliged to pay by the 10th of every month. And Milord, I have
the order was passed.
The order was passed in the month of February 2025.
So 10th of March.
10th of March.
Matter is pending.
Yeah, very.
Mr. Mitro, don't take any precipitative action in the meantime.
I will tell my.
And I have, Milord, 15 dates with me. I have.
Bhattacharya, do one thing.
My lord. I'll put a supplementary affidavit if you
Did not put a supplementary affidavit for that, but you get a photocopy of these order sheets.
Is all right?
The entire order sheets, I think from
Now, order number 100 onwards, my lord, it's better.
100 onwards.
102, my lord, 126.
Get certified copies of those orders and give a copy to Mr. Mitra in advance.
Very good.
He
Very
did
good.
not file. Mr. Mitra, are you insisting on a supplementary affidavit to be filed?
Order will suffice. As well from your lordship, my lord. And your lordship kindly takes on 13, my lord. I will.
13th is a lucky day for you.
Well, I will.
Mr. Bhattacharya will not be available from 13th.
Where will I go?
He will be there.
My lord, where will I go? I will be. My lord, I do not have the places to go, my lord, unlike my lord. And my lord, today it's it's a nice day for us, my lord. We should have gone for a holiday. One of our honorable judges, my lord, elevated there, and that too, my lord, to the highest level.
Yeah.
It should call for a holiday. Your lordship is sitting.
Hello, when a heavyweight lawyer like Mr. Bhattacharya is appearing against me, I have also to see my luck also.
Ashun.
দাদা ছোট করছো কেন?
Come at 2 p.m.
My lord. I'm grateful, my lord.
9 of monthly, but this matter squarely falls under the Gautam Hadas case. But they have raised construction and the ground floor is almost complete. If they will not raise the
Ground floor complete.
almost complete, within 2 or 3 days it will be completed. And
Entire thing will be demolished. If they construct up to second floor, that will be demolished.
if there is a stay, my lord, of the temporary injunction. So if my lord bears out the matter, my lord,
I will hear out.
The revision will become infructuous.
Why revision will become infructuous?
But that is solely on that ground.
When have you filed that? When have you filed that application?
That I have to check the case.
My lord, may I?
But I have mentioned this matter.
This is not the mentioning time, madam.
First, one small injustice, my lord. I am hearing this item number 47. My lord, yesterday, my lord, was pleased to fix this matter on 10th March at 3:30. But mistakenly, it is appearing this is the item number 47.
ওটা দেখে নিন item number 47.
My lord, it is appearing for the petitioner and Mr. Shivakumar.
Item number 47. Item number 47 টা দেখে নিন একবার তাহলে ওটাকে মার্ক করে রাখুন।
Kindly bears out this matter.
It will be taken up. Monthly list is being taken up.
109 within these 2 days, within these 2 days, the construction will proceed.
How much? Within Kolkata Municipal Corporation.
Bakuda.
If within Kolkata Municipal Corporation, Mr. Ghosh is here, he will see that illegal construction is demolished.
Kindly,
Please use the microphone. Yes. Oh, the Jalpaiguri. Lift to file.
Lord, I'm sorry, my lord, to item number 8, my lord. I could not follow the list, my lord. That's why my lord dismiss or default, my lord, kindly consider.
What can be done? Take out an
My lord.
application. Item number?
8, my lord. My lord, kindly consider.
What is this matter?
My lord, a PMSN case.
Yes.
Lower court reject and appeal court allow.
Lower
It is
court
that
reject on what ground?
on ground because of the relation between the transferor or transferee. And subsequently, appeal court allow that the first time, when first sale, this is the third time sale, they file the PMSN.
ওই item
Not the first time sale.
ওইটা ফাইলটা আনিয়ে নিন তো
8.
Wait. After this matters, it will be taken up.
Today?
Yes, yes, today. Otherwise, that order will remain.
So my senior is not here.
That I do not
Even
know.
the better.
Yes. হ্যাঁ. Not filed a certified copy. This is transfer. Or transfer certified copy থাকবে. Yes.
But it will be taken up today.
Yes, yes, today. Yes. Call the other matter. 2 p.m. 2 p.m. যেটা আছে.
Item number 11.
Where is he? Our dismiss for default. Yes. Next. No, যেটা 2 p.m. যেটা রেখেছেন dismiss for default সেটা কল করুন. Where were you? It has again been dismissed.
No, I'm moving slow. That is the reason, my lord. I've suddenly suffered after that.
Yes. What is this matter?
My lord, transport is not contacting its property. I have defendant,
Lanet trial court is not functioning properly. Why?
when I am the defendant owner of the land.
What is your prayer?
Prayer is the
Section 24.
yes.
Yes. On what ground you are paying for transfer?
My lord, NSC so. My lord, first of all, summons not served either by poor or by bailiff. It's been recorded in the order sheet, and the lawyer was compelled to take copy from the record. That was 31st March 2023. So he filed the written statement on 21st June 23 within 90 days. Even thereafter, put a post expiry hearing and applied for vacating expiry and sitting as accepting the outlays. It was rejected, giving further liberty to make proper application. Again, another application filed. That was heard by another judge. He also said, no, it is not proper to file another application. Now, see, another application filed. Now, if kindly come the last material application, that is at page 42.
42, yes.
This application last filed before the court below. That your honor was pleased to reject the application filed by defendants on 26/4/24 by order dated 3/12/24. But defendants were
Accept
directed
the
to
written
file.
statement. What happened to this application? You have filed this application to accept your written statement. What happened to this? Written statement accepted?
Not accepted.
Why? Where is
Why?
that order?
My lord. That is the order dated 3/2/24. 3/2/24, but page 37.
Page 37.
Yes. Fine.
So you are directed to file an application for setting aside from the ex parte board.
Yes,
What happened after that?
thereafter I filed an application.
Where is that?
That is,
So you have not,
that
which
is,
order you have challenged?
my lord, I challenged the, I did not challenge that, I only annexed the last order dated 3/12/24. That is the original certificate copy.
3/12, 3/12,
That
you
is
are
the
challenging this order.
Or the order copy was annexed. I have paid for the transfer of the case. This is the last
What
order.
ground?
This is the one with can you see the order sheet, enter order sheet, that always injunction is being extended, double is not
You
accepted.
have to challenge those orders. That cannot be a ground for transfer. That cannot be a ground for transfer. You have to, if you are aggrieved against any order being passed,
Then my
you
lord,
challenge those orders. You have not challenged any
then my
orders.
lord, that order maybe challenge the order
That is that. You have not challenged anything and you have not also filed the certified copy.
Yes, I have filed certificate copy.
Where is that? Which order?
Order dated, this is pen written, order dated 3/12/24.
You are challenging this order.
Yes.
Where have you paid for that? In the cost title, you have not said that you have challenged that order. You have paid for transfer.
Yes.
Transfer cannot be on that ground. Orders are passed, you have to challenge those orders. If an order is passed against you, that is the ground under section 24.
My lord, if I refer on judgment of Honorable Supreme Court as reflected in 2008 volume 3 659,
yes.
Some points are উল্টো পাল্টা করে দিয়ে দিয়েছো। At page 14, if the allegation is that,
give me a copy.
That the, a second.
Page 14. Point 14.
Paragraph 14.
Yes, which ground you are invoking here? Show me from your pleading which is the ground you are invoking of paragraph 14.
My lord, come from paragraph 8 onwards.
Yes.
Of the application.
Yes.
Paragraph 5.
Yes.
The written statement which was filed within the time has not yet been accepted on various frivolous pleas and orders, causing waste of time of the court, completing the matter in order to dilute and frustrate the title of the petitioner in the suitland, and surprising the plaintiff respondent is also.
When you have received summons?
He will not receive. I took out from the court record. The summons not served, and it recorded in the order sheet also.
Where is your application for acceptance of the written statement?
There are 3 applications, at least 2 applications.
Yes.
One is at page 18.
Page 18, yes.
Yes.
What order was passed on this application?
File 183 to order was passed. Oh ma. Order was passed on the application. 4583. No, excellent. ওটা না চেক করো। One and three.
You filed the entire certified copy.
Yes, I have.
Entire certified copy. This application is at the instance of the
My lord, in the meantime, no, my lord, I don't pray for stay.
Don't pray for stay. Yes, thank you.
My lord, stay hasn't prayed. My lord, for the timing, it may be for this 21 days. For these 21 days.
First, bring the certified copy.
My
Then I will consider your prayer.
my lord.
Don't pray for stay now. Yes. Call the next matter.
Before.
Yes, Mr. Rai.
A petition under Order 13 Rule 7 has been rejected. The suit for
Yes, you are
declaration.
trying to fish out evidence.
Every application under 39(7)26(9) must freezing out evidence.
That will be the ground for
For the
rejection.
purpose of filing an application for injunction, because this is a suit for declaration injunction, permanent injunction. In such a suit, my lord, kindly consider, because otherwise, my lord, the status quo will create problem for the purpose of if any order is passed. Because both the parties are claiming to be in possession and the status.
Where is your application on
Yes,
the order?
my lord. Kindly consider the application that is at page 23.
23. Where is the points? 24.
Yes, point is 24, my lord. Kindly consider paragraph 3.
Paragraph
3 reason. To some extent, the reasons are to be mentioned, my lord, for the what reasons.
You are the defendant.
And the defendant. And the purchaser subsequently added as a party in these proceedings. Only my lord, 4 is the main point for the purpose of injunction. Because everybody is saying that well demarcated portion they are in settled position.
So you want only with regard to point number 4.
4 and 5. These are the, my lord, these only for the purpose of topography. Otherwise, my lord, both are claiming to be in possession of the property. Both, I am claiming that I am making construction, I am in a settled position of particular portion by a demarcation.
Plot number 210.
Yes.
Where is your suit?
Yes. My
Oh,
lord,
sorry. Where is the plaint?
Plaint, my lord, it starts from page 12. I am drawing lots of attention. So for the relevant portion is that
You are co-sharers.
according to us, my lord, previously it was a partition. My lord knows the same principle.
Prior to 65.
According to, after that, everybody transferred. It is not the first time. Transfer by changes are there.
So a sale deed executed by defendant numbers 4 to 8.
In favor of this defendant are baseless voice with a prayer for declaration that the death certificate is void.
Forged, not void.
Forged. The deed for
You are
declaration.
producing forged death certificates.
According to the, because unless they said it is a forged.
Sale deed executed by defendant numbers 4 to 7 in favor of whom?
The petition before your lordship.
In favor of the defendant numbers 1 to 3.
No, 12 ABC.
Or 12 ABC. And the deed of sale executed by 3 and 8 in favor of defendant numbers. You are 12 ABC.
Yes.
So this is the suit.
This is the suit.
And
Now, if your lordship kindly
not
consider.
to disturb possession, cost schedule. What is cost schedule?
Now, I can turn to the cost schedule. It's
210 is also one of the plot of cost schedule.
Yes. 210, I had got it, Bastu.
210 Bastu, yes. 210 is
27 decimal. So, but apart from these plots, I have no
12.60 out of 27.
27. So,
Where is your written statement?
Statement.
What is the allegation against you in the plaint?
Plaint not against me, against the other defendants who have transferred the property in favor of us on the ground that it was executed by a person.
This application for local inspection is in aid of injunction.
In the aid of injunction.
So what is the injunction paid for against you?
No, there is no injunction because This
So,
is
Mr. Rai, why this is necessary?
because my lord, once injunction, I file an application for injunction.
For injunction.
I require to file an application for injunction because I am
File an
registered.
application thereafter.
After that, application will come.
Then
My colleague,
there is nothing on record to show now, and you are this is fishing out
That-
of evidence. What
that
did the learned trial judge say?
yes, my colleague counsel, what the learned trial just said. Learned counsel defendant number 12 Kokogo prayed for local inspection to bring out the nature and topography of the superintendent, including the
The
houses.
defendant the plaintiffs tried to change the where is that allegation that they are trying to change the nature and character? There is no allegation.
This is the application.
Yes.
This is the application.
No. So if they are trying to change the nature and character, you have not paid for any injunction. Rightly, yes, Ashur. This application under Article 220.
Well, this is my application, my lord. I'm for the
Yes.
my lord, defendant, my lord. My lord, I was being cross-examined, my lord. During the cross-examination, my lord, I had filed an photocopy of a payment receipt, which
You have filed
photocopy of a payment receipt, which was marked as X for identification. On the next date, my lord, I was supposed to file the originals of that photocopy, my lord. I sought adjournment. The learned court rejected my application, saying that no more time can be granted, and my evidence was closed and fixed the matter for argument. But only that original receipt of the payment which I want to, my lord, I presented that on the next date on the date of next date, my lord. But unfortunately, that was rejected, my lord. I have come up against that order, my lord. My lord, on 18/11/2024, my lord, I submitted the document, my lord, which was marked as Y for X for identification, my lord. And the next date, my lord, was fixed on 2011. My lord, only one day was granted to me filing the
That is
original.
the order dated 15th of November 2022.
15th of November, my lord, that has not
Yes.
been annexed over here, my lord. That is
You have
not
a copy of that because we wanted to
unfortunately-
show that payment receipt to show compliance of that order.
I have already on the last
Show me
date,
that
my lord,
order.
on the last date, I
The
already
Learned trial judge has said you can file that same along with a firisty, that will be
my lord,
sufficient.
that is there, my lord. In
So-
fact, I had already, my lord, only one date, my lord. I will just exhibit my document, my lord. Only one.
Not needed. The Learned trial judge has said you can file by way of a
But
firisty.
already, my lord, this suit is filed by a mutawalli, my lord. Suit is itself is not maintainable before the trial court.
Raise that point in the argument. Suit will be
One
dismissed.
date may be given so that I can
Not
mark that-
necessary. The Learned trial judge has given you liberty to file that along with a firisty.
that liberty may be given.
No, that liberty is always
liberty
there.
my lord. That observation may be recorded here, my lord.
What observation? That is already in the.
It is there in the order, my lord. That Great, my lordship.
Disposed of with the above observations.
Great, my lordship.
Yes, next.
Madam, for the petition. Here, my lord, the plaintiff opposite party filed an application under Order 6, Rule 17, when the, my lord, cross-examination of DW was.
Who filed?
Plaintiff, my lord,
Opposite party. Order 6, Rule 17 allowed.
Order 6, Rule 17 allowed when the cross-examination of DW1 was going on.
At the stage of cross-examination.
Cross-examination. PW has already been completed. Now DW is going on.
What is the suit for?
Suit for, my lord, declaration that he got the property by of gift and injunction.
He got the property by way of gift. What is the proposed amendment?
Proposed amendment that we have, my lord, relied upon, we have produced one deed. Exhibited one deed. He said, my lord, he have no knowledge about the deed. So he want to put an abatement.
So that deed was produced during your evidence.
Now, my lord, if I admitted something that is not required to be proved, so what is the use of this, my lord?
If you have produced something, proviso explanation.
This will understand
My lord, this is my matter, my lord.
Party, I'm paying for an adjournment.
My lord. My lord will kindly, my lord will kindly see the last order. My lord, I am alienated from my child for the last 1.5 years. I'm suffering an order of June 2024, my lord. Matter has been pushed around for some time. 8 months. My lord, the matter was fixed when in presence of Mr. Bhattacharya and his juniors, my lord.
Where is Mr. Bhattacharya? In his presence, it was fixed. He said 7.
My lord.
My
lord.
record is not present today.
My lord, the advocate on record was also.
The arguing counsel is present.
Yes, my lord.
It was fixed in their presence.
My lord,
You are putting the court in
I
embarrassment.
have not met my son for more than 1.5 years, my lord. And my case is of alienation. I'm running a case of alienation, my lord.
When this matter is taken up for hearing, an accommodation has been paid for.
My lord.
Yes, Mr. Banerjee.
Matter.
Of the opposite party,
Take the bench.
sir, on behalf of the opposite party, the Molar Bhattacharya is appearing as my leader. He has suffering from surgery.
He's suffering from?
He has got a surgery, as I informed yesterday. Yesterday, another matter appeared between the same parties, which has been fixed on 26th.
I just indicate one thing. My lord, this is with regard to custody and visitation right. My lord, I am from an interim order, so
You are the
father.
You are the father.
Father. My lord, the girl child who is now, my lord, 7.5 years old, almost she is, my lord, staying with her mother. Mother, my lord, took her, my lord, when she left the matrimonial home. Now, initially, there was, my lord, an application filed by me, rather a suit, my lord, for restitution of conjugal rights, where, my lord, a joint application was preferred by me and, my lord, the mother of the child, saying that the mother, my lord, would carry the child to Joy Krishna Library. My lord, I am at Bhadreshwar, she is at Uttopara. So, my lord, Joy Krishna Library. And, my lord, every Sunday for 6 hours. That was a joint prayer. That was allowed. My lord, the mother was not abiding by that. Then, my lord, I filed, my lord, an Act 8 case, where, my lord, I took out, my lord, an interim application. My lord, in the opposition, mother says that even if, my lord, the child is allowed to talk to me over, my lord, VC, virtual mode, my lord, for 10 minutes a day, my lord, the interest of the child will be hampered. That's, my lord, the kind of resistance, my lord, I am facing.
What is the impugned order?
My lord, it says that, my lord, she will take the child every working Saturday to the court, to the court premises. Every working Saturday means, my lord, once in a fortnight. So, my lord, twice in a month and in court. My lord, I am sorry to hear that Mr. Bhattacharya is suffering. May I, my lord, meet the child this Sunday for some time and will come back. And if my lord so desires, my lord will kindly, my lord, interact with the child.
Yes.
I want this matter.
Who will submit?
Lordship, I am appearing on behalf of the opposite party number 2, led by my senior advocate Molar Bhattacharya.
So I think he is the junior of Mr. Molar Bhattacharya. I am the caveat. So
You are the caveat. Who are? Oh, you are the. You have lodged the caveat.
One opposite party.
There are 2 advocates now coming. One advocate has lodged the caveat. Another advocate is appearing.
She is representing opposite party number 2.
My mistake, Lordship.
Opposite party number 2. There is only one opposite party.
My mistake, Lordship. There is opposite party.
Oh. So one advocate has lodged a caveat, Mr. Banerjee, and another is.
May I meet the child this Sunday for some time?
my client has Mr. Bhattacharya, my senior.
No difficulty.
That I appreciate. I appreciate that very well. That another advocate has been engaged. Do you have any objection to the father meeting the daughter this Sunday.
Next week, I can.
Not next week. I can keep it at 3:25. Take instructions, come. Yes.
May
May it please your lordship, Lord, and for the petition. But this petitioner has come with your lordship being a defendant in a suit, which was a suit for recovery of possession, my lord. My lord, by an order dated 20th of November 2024, whereby, my lord, an application under Order 7, Rule 11 was filed on the sole ground, my lord, that there was no cause of action. My lord, that was turned down. My lord, this petitioner happens to be a defendant number 2 in the suit. But the factual matrix of the case is, my lord, that a lease was executed in favor of, my lord, the pro forma defendant. Thereafter,
suit has been fixed for argument.
my lord will kindly consider why I tell your lordship. Your lordship sees
Arguments, let you raise all these points at the time of
your
hearing.
lordship knows, my lord, that Order 7, Rule 14 mandates, my lord, the cause of action, what they are alleged is that there was an illegal construction. My lord, that has to be.
I appreciate that the suit is at the argument stage. Raise all the points. Raise all the points. Evidence,
Your
everything.
lordship, my lord, can decide this here itself. And this is, it should be, my lord, outrightly, my lord, because if there, my lord, I am relying upon a
Since
judgment.
evidence, everything is concluded. It's at the argument stage.
My lord, I am
It's at
relying
the
upon
argument
a,
stage. I cannot reject this here and now. I have to direct service. So they have to come. So it will further delay this. So it has been fixed for argument when?
my lord, that, my lord, it was fixed on 6th of March yesterday.
Yeah,
I have
no,
to take
6th
instructions
of
from-
March. So next date will be prior to the
We have
matter.
taken adjournment probably, my lord, in the trial court below, saying that this matter will be heard by your lordship. My lord, because
So now what is the next date? I am directing.
my lord, the advocate on record, perhaps, my lord, was, well, 6th March yesterday, there was a date.
All right. So I am directing that I am giving you liberty to raise all points at the time of argument.
hang upon a judgment, my lord, perhaps.
Take all points in the.
I'm good, deeply.
Plaintiff is the petitioner of your lordship. Before going to the order impugned, my lord, I am drawing lordship attention to the 2 or 3 amendments made in the plaint,
What is the order impugned?
rejecting my application for local inspection. Kindly turn to paragraph 12.
Local inspection. Order 39, Rule 7.
Rule 7.
Plaint, yes.
If your lordship can turn to
You are the plaintiff.
yes, if your lordship can turn to paragraph 5.
Yes. Yes, paragraph
Your,
5.
your lordship find sorry, my lord, paragraph 4. The said Mathur Chandra
Paragraph
Ghosh.
4.
Yes, my lord, I beg to be corrected, my lord. That said
Yes.
Mathur Chandra Ghosh while exclusive possession of the suit property because he was the sole owner of the property. He constructed the mother of the dwelling house and subsequently constructed such and such. Made boundary in the southern side, eastern side, and western side of the suit property with such and such land, and she subsequently died, and here remained the wife. And so initially the Mathur Chandra was the owner by a demarcated exclusive possession of the same. Now, my lord, pause here for a moment, my lord, can turn to paragraph 5.
Yes.
That while the legal heirs of Mathur Chandra Ghosh were in eligible possession of the said 15.5, this is the area which Mathur Chandra Ghosh used to occupy.
Yes.
Niman Chandra Ghosh died living behind such and such. And Anita Ghosh, plaintiff number 224, thereafter Bimala Ghosh died living behind only son Joy Kali Ghosh. That the plaintiff number 5, thus plaintiff number 224 became the owners of 1.33 decimal of land. Each of the plaintiff number 5 became the owner of 4 decimal of land. Therefore, that of Mathur Chandra Ghosh, all the legal heirs Mathur Chandra and defendants are being co-sharer of the suit that mutually agreed to call surveyor, and after measuring the suit property along with other property, site plan was drawn by Amin. Uttam Chandra settled their previous position and settled their previous position in accordance with the site plan drawn. So, my lord, this is if partition was defected, subsequently reduced in plan. Am I clear to your lordship, my lord? It is not a case that this is the document which creates title over the property. The co-sharers are there, prior partition, reduced in writing. Now, my lord, can you turn to paragraph 12?
Yes.
The defendant, the owner of the rest portion of the property,
Yes.
and I mentioned that how that property was delineated or demarcated along with the plaintiff's property.
Who is the transferor of the suit property happens to be the owner.
Yes.
6.5 out of 22.
Yes. And the residue belongs to this plaintiff. This is the defendant's share. And I have categorically mentioned in the southern side, suit property is measuring 8 feet wide and 60 feet. And they use as a passage, and the rest measuring 5 decibel is situated at the western side of the measuring 5 decibel of the various
Yes.
plots. So these are delineated. I have delineated the portion which belongs to the
Passage.
Now, my lord, can you turn to the written statement, page 19, internal page 4.
Yes.
My lord, got it at the top, my lord, your lordship will find. This was the case made out. First 2 lines.
Never demarcated by the co-sharers.
The legal heirs of Mathur Chandra Ghosh and the defendant's name are called any surveyor for measuring the suit property such and such by Amin Uttam Chaudhary, settle the property in such way. The site plan, as stated by the plaintiff in their plan, is a manufactured and void document.
Where is manufactured and void?
At the middle portion, your lordship will find that 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 from the top. Same page.
Yes, yes. Is a manufactured and void document.
So this was the stand taken by the defendants.
Yes.
Now, apropos to this, my lord, can you turn to page 22?
Page?
Page 22, Kale judgment, Kale.
Yes, what is page 22?
My application for localization, the schedule.
Yes.
Can you turn to D? B, C, and D.
Mr. Rai, there is your case is that uh, it is a properly demarcated by way of a site plan.
Yes. Not
Yeah,
only
this-
that. That is after that it was well previously it was Mathur Chandra Das while in exclusive position he demarcated in such a manner.
Yes, so demarcation that is in support of that to prove that is the site plan.
This is site plan. They said
Say site plan. So the defendants, they are disputing the site plan. They are saying no, this demarcation.
no, they are saying that there is no demarcation. It is a case.
So according to them, there is no demarcation.
There is no
So
demarcation.
this
no partition.
partition, as per the site plan, yes or no, that is the subject matter of the suit that is to be proved. By way of local inspection,
That is what the delay. That is what if you logically consider. Today, if you logically, I can
how the commissioner can decide whether there has been any demarcation or not.
demarcation. That is why B, C, and D. And
Yes, B is there any demarcation? Is there any demarcation? That
yes,
is what we are saying.
the boundary is there. That is why, my lord, you logically consider plate once.
No, is there any demarcation over the boundary?
Yes, no. Page 9, my lord, can you turn to page 9?
Page 9 of the
Revisional application. That is the page, paragraph 4 of the plaint.
Yes.
He constructed the Paka building over the suit property. Not only that, my lord, got it?
Yes.
He made his boundary in the southern side, eastern side, and western side of the property with betel trees and some coconut trees in the northern portion of the land of the plaintiff, Dag number 3848. She subsequently died in the year 1970. So what he was enjoying, it is a demarcated portion which he was enjoying, pursuant to which Amin was executed. So I have to prove, my lord, not only the partition affected, but the partition was there, subsequently reduced in writing. Otherwise, my lord, can you consider 14 of the West Bengal Land Reforms Act?
Mr. Rai, the partition of oral partition, according to you, there is a oral partition subsequently reduced into writing.
Yes.
So oral partition you have to prove by way of evidence.
That is
Cannot be by way of this commission. Commissioner will go and see, yes, this boundary wall. So partition, that cannot be.
no, that is only for the purpose of holding that the existence.
It's a matter to be proved by evidence.
Well, evidence, if you logically consider today the evidence, whether there is any tree.
Because your evidence is the site plan and there must be oral evidence. So you have to, you know better how to prove oral partition.
Oral partition reduced in writing. Well, oral partition reduced in writing.
Two things. You have to prove that oral partition and subsequent that has been reduced into writing. So you have to prove that. So if it has been reduced into writing, how? So you have to lead evidence on that. So commission cannot be an evidence that oral partition.
Not on that. I am on the existence of that wall is there or not, because their denial is that they're enjoying.
Let us assume that there is existence of wall. Let us assume for the present there is existence of the wall, but that does not prove. That does not prove that there is partition.
No.
Your endeavor is to prove that partition.
My endeavor is to prove that Mathur Chandra, by way of this schedule, was enjoying the property. This is my
Show me how this paragraph 4 has been dealt with.
Yes, my lord. Can you turn to this statement? Paragraph 9 is total denial.
Paragraph
9. There is no case made out by the defendant.
Yes, this case is there. Case is for paragraph 10.
Yes.
Let us.
Can you consider what the case made out? It is not a case made out. Only case is that there is no partition.
Mr. Rai, give me a minute. So paragraph 10, their specific case is never handed over possession with specific demarcation.
Yes.
So this is a matter to be proved by evidence.
Defendant. by the defendant. My
Yes.
case is that
Proof by, there is a documentary evidence.
that is
Mr. Rai, there is a documentary
to
evidence.
that extent, my lord, that is a map of the Amin.
Yes.
If the existence,
Prove that map.
my lord,
That is the evidence.
this should be related to the, my lord, every application or order for this is rule line of 39(7), my lord.
Some sort of
Some
fishing
sort
out.
of fishing out evidence. Nobody can say, my lord, put this
Mr. Rai, yes. But what is the object? Object is to bring the picture from the local before the court. So here is the
Yes,
case. Mr. Rai, there is, the case is whether the property was partitioned by meets and bounds with specific demarcation. That is the thing. So according to you, it was partitioned orally. Subsequently reduced into writing, there is also a sketch map. Their case is that the sketch map is a forged one or manufactured one. So these are to be proved by
one can consider if the case map is,
even if, let us assume, even if the commissioner goes to the local and submits a report, yes, there is a boundary wall and other thing. Does it prove partition?
I'm not on that. So I am on the basis that it was effected and acted upon. But can you consider why? It is a paragraph 4 of categorically stated that what was the position of the land at the date in the year 1974, 67. Still it is there. So the topography of the plot, because it is a suit for partition, is not a, by way of 3 parameters which is mentioned in section 14 of the West Bengal Land Reforms Act. This will be covered only on the ground that previous partition was effected.
Mr. Rai, how can point D be decided by in local inspection?
Everything has been, it is for bylaw to decide what are the points to be, if at all.
So this 8 feet passage.
Yes, 8 feet passage, because it was mentioned that 8 feet there is a passage.
So can the advocate commissioner go to the local and decide?
If bylaw is of the opinion it is 26(9), then
can be converted to
26(9). I am not on that,
that is a different thing altogether. But
so the length and breadth, whether the advocate commission is
Mr. Rai, the only dispute is
the topography of the land. Because what can you consider?
Dispute is
the topography.
So title and possession, and this is the entire thing. So there is no dispute with regard to your extent.
No, they are saying it is HON'BLE. So there is.
So 15, yes. So they are saying, Mr. Rai, they are saying HON'BLE, you are saying it's partition with demarcation. That is has to be proved by way of documentary evidence.
Documentary, that is why
documentary or oral evidence.
Oral evidence, Kali consider. I have stated in my plan that was the topography of the land in the 1967 when parties, the Mathur Chandra was the owner, got the property and he used to utilize the same in that manner. Whether the existence of that was still there or not, because I have to prove relates to the date when he was in possession of the property.
What is the stage of the suit?
Preliminary issue. Preliminary issue.
So let us assume that you fail to prove this sketch map and other things. So if the court feels, at a subsequent stage, court will consider.
Otherwise, if you're lordship,
Mr. Rai, if you fail to prove that oral partition, these sketch plan, everything goes, local inspection report. So at any stage,
then also can you consider whether the oral
at a subsequent stage, if the court feels, because it's for the requirement of the court, if the court feels at a subsequent
because
stage,
only thing I can overcome in view of section 14, because I have to reduce the writing, because section 14 is troubling. It is
that is why.
That is why, my lord, that is why, my lord, I categorically said the affected.
So you said, Mr. Rai, that there was an oral partition subsequently reduced into writing and there is a sketch plan. Amin was there. You have to prove these facts in support of your case.
If that only, my lord, but previous partition was defected. My lord, there is a distinction between that on the basis of that map, it was not created. It was not that on the basis of that map. It was the creation reduced in the map. My lord, can I clear to your lordship? It is previous partition reduced in the map.
Show me that.
Yes, my lord. Can you consider? If your lordship, can I turn to paragraph 5, my lord, once, for the sake of.
Give me a minute.
Yes, my lord.
Yes, so if you prove the plan, Mr. Rai, your case is that there was the previous partition. So we are possessing in accordance with that. So that measurement was, but this is intersect between the plaintiffs.
Yes.
This is intersect between the plaintiffs. So according to you, that previously it was orally partitioned, we were possessing in terms of that, but subsequently, in order to avoid future complications,
Amongst the plaintiffs.
we have called the Amin, we have surveyed, and that was a plan was drawn. So in terms of that, now we are paying taxes. So you have to prove that plan
My lord,
and
this will not
of the earlier partition.
this
This has nothing to do by
my
local
lord, this
inspection.
plan will not. Here the plan between the plaintiffs. My lord, kindly consider this.
Yes.
So this is the plan between the plaintiffs. So I have to prove something was there prior to execution of the plan. That is the portion how they have enjoyed. That paragraph 4 of the plaint.
Yes, paragraph 4.
Your lordship kindly consider. So at least I have to bring something before the court that yes, what I mentioned in paragraph 4 it still exists.
So this boundary was made because you are claiming exclusive title in respect of
The out of
15.5
out of 22.
out of 22.
Yes.
Mr. Rai, this paragraph 4 does not speak of the co-sharers that it was partitioned between the defendants and petitioners.
Well,
You have, let us assume you have constructed a boundary one.
Yes, if your lordship
That is, according to you, show me that you have stated that
yes.
mutually between the defendants or the predecessor of the defendants and yourself, this was partitioned.
Yes. If your lordship can turn to paragraph 3.
Yes.
While they are in exclusive possession of the suit property along with other properties, they transfer land within such and such. Who are the same? The Upendranath Ghosh and the others.
Yes.
Can you consider?
Yes.
Along with the properties
Handed over possession with specific demarcation. So this, after that, you have constructed a boundary wall. So you have to prove first, Mr. Rai, you have to prove your case in paragraph 3 first.
Yes.
So then on the basis of that boundary, so boundary wall is nothing. So you have to prove the earlier partition by virtue of this with specific demarcation as per this 1967 deed. If the deed contains demarcation, end of the matter. If it does not contain demarcation, even if you make a boundary wall, that is not a partition. Asun, this application.
One thing was subject to question, my lord. If your lordship can consider paragraph 10 of the written statement once. What is the case made out? What is following from your lordship? If I read in that way, the entire land middle portion from the
paragraph
10, page 18, the defense case.
Page 18. Yes, yes. Yes,
The title of the play, Madhav Chandra Ghosh was denied after that.
Which line, Mr. Rai?
Last bottom, 4th line from the bottom. My lord got it. Because
Madhav Chandra Ghosh never transferred.
Yes.
Yes.
If that be so, my lord, can you consider, if that be so, then how they can say that by way of kosher they are enjoying the property?
No, Mr. That is a matter of evidence.
That is why, my lord,
to be proved.
I have to privacy.
Whether you have got, as per the 1967 deed, you have got a specific portion or not, that the deed will say. So, if you have to prove, according to you have purchased this, your predecessor, that Madhav Chandra Ghosh
Yes,
or something.
Madhav Chandra Ghosh.
So, he got a specific property with specific demarcation by the deed of 1967. So, if the deed does not contain demarcation, you're making this boundary wall is.
And that was acted upon. That I have to make
acting upon will come subsequent is past.
Now, my lord, if the court, because once, my lord, if your lordship I reject my application, then, my lord, subsequently, if it appears, my lord, I can apply for the same.
What?
For local inspection, because it is required in, because after that, the topography.
Is it required? Because the fact is, what the local, let us assume.
Is allowed.
Let us assume that the local, the advocate commissioner reports what you have stated in the place. Let us assume that.
Then, my lord.
So now let us say or assume that you failed to prove that you got that specific demarcation by virtue of the deed of 1967. So that is the parent thing. If you prove that,
Yes.
everything falls.
Then, my lord, at least
Even
if I
we-
prove that, then it was acted upon, that will be this schedule.
Not necessary to act upon, because in the deed, let us assume a person is an exclusive owner of 20 decibels. So he sells 15 decibels demarcated portion. So it's not a partition is not necessary,
Yes, sir.
because by virtue of this, you get the purchaser
Exclusive.
gets exclusive over that 15 with that demarcation. It's the situation otherwise, if he sells 15 decibels out of 20 decibels,
Without
both
demarcation. Then
both
how-
becomes co-sharer. But if it is with demarcation, so it's both are exclusive owners. So you have to prove this 67 deed. Even if it is proof and you fail to prove your 67 deed,
everything goes.
so your right or your claim is based upon that 67
Yes.
deed.
I want to prove that it is not only it is mentioned, but it is
Acting upon will Ashok. This application under Article 227 of the Constitution I could have decided that part also, if the deed is there.
That is why that portion.
Thank you. Yes, next.
Get from your lordship. 41, my lord, before your lordship takes up, my lord, there is a caveat by Mr. Bhattacharjee is probably from the chamber of Mr. Bhattacharjee, this caveat was lodged.
All right. So, since I'm not inclined to take up this matter on personal ground, this matter stands.
Every doctor done.
I'm appearing on behalf of the petitioner, my lord. On the last occasion, today was fixed because the caveator has lost a caveat and that's why the copy has been served. So I had made fourfold submission before lordship. Four false prayers were there, your lordship. One is litigation cost.
Before
from
my
the
learned friend submits, but only one maintainability point I'm taking, my lord, regarding challenge of the order dated 31st August 2023. Although in 227, your lordship has a vast experience, there is no period of limitation, but there must be a body explanation in the revision application number 1. Number 2, my lord, he has accepted the money in terms of that order, and he, on the contrary, lodged a caveat before this court. Therefore, regarding this order, 31st August 2023.
31st August, how are you challenging now?
My lord, thereafter I have filed 151 application, my lord. That was actually disposed of dismissal.
You have
Challenge two orders.
Notification of this by filing an application.
I have
went after 2 years.
Your lordship, that
Where is your application under section 151?
my
Show me the
application-
prayer.
Yes, your lordship. That is in
121.
yes, 121, your lordship. Not 121. This is your objection. My application is 113, your lordship. If I'm not wrong.
113 is the income tax return.
Your lordship, 110, your lordship. That was filed on 25th of September 2023. Your lordship.
110.
That is my 151 application. I have asked for 2 prayers, your lordship. One is from the date of filing, which was not done in my matter.
Oh, initially in the 31st of August 2023,
Yes.
the order was from the date of the order.
From the date of the order.
So you filed an application under
I have
section 151.
Yes, your lordship.
Yes, Mr. Mukherjee's modification.
No, not that. Very well, let him, well, because if you let him see the.
First, the delay part you are taking.
Yes.
So, modification is, it should not be from the date of the order, from the date of the application. So, then the next order was passed on
On 29th of November
so that delay
2024.
goes because it was really a modification of that.
But kindly see this application. This was filed.
Which application?
This 151 application.
Yes.
File kore
25th of September 2023.
25th of September 2023.
Kindly give me 1 minute. But kindly see the cost.
So, after within 1 month of the date of the order,
But in the body of the petition, what he has stated that the income has been increased. That's why if
this is a substantive application, 151.
Yes.
Body of the application, Mr. Mukherjee, if it is to be seen
Anyway.
in every matter,
Then my lord, he must my lord, submit that this is an application only for the modification to that extent that the amount has to be paid from the date of filing of the application.
Your lordship, there were
yes,
four.
that is the application.
Yes.
That
there
is the
were
application.
Four suggestions. I mean,
No,
prayers.
2 things. One is, initially an order was passed in August 2023.
Yes, your lordship.
So you have filed an application under section 151, which was disposed of by the subsequent order.
Yes, your lordship.
So kindly come to a prayer at page 111. What was your prayer?
The prayer, yes, your lordship, the prayer was,
Since the date of filing,
yes, your
so this
lordship.
was the only
And the-
modification
and the
you
litigation.
wanted.
Yes,
So
your
your
lordship.
prayer will be restricted only to this.
Yes, your lordship, but thereafter there is an order passed on 22nd July, your lordship, in 2024. I have prayed for enhancement, your lordship. The DLF report was
Enhancement is,
also,
madam, enhancement is not as per this application. Enhancement
your
you have
lordship.
not paid in this 151.
Yes, your lordship.
151, you have only said it is to be from the date of the order,
But
from the date of the application.
in the middle, your lordship, from filing this application in the dispose of, that is 29/11/2024, I have filed the documents of DLF report for enhancement, your lordship, and I only prayed
Where is
for
that
it.
application for enhancement?
Your lordship, that the application I haven't filed, but
Then-
I have filed this
Then how could
DLF
have been
report.
enhanced?
That was already recorded, your lordship, on the last order, your
But
lordship.
you have not
on
prayed, you did not
29th.
get any opportunity to deal with that.
Your lordship, kindly
Has it been enhanced?
see, your lordship, there was specific order related, kindly. There was specifically stated that if any objection thereof, they should file in the meantime. Kindly see the order sheet, your lordship.
Application, they, show me your application. Then the question of objection will come.
My lordship,
Madam,
my
show me
lordship,
your
everything
objection that
was,
you have prayed for.
everything
Because,
was,
they could not be taken by surprise. At the time of hearing, you will say, yes, it is to be enhanced. That cannot be
your lordship, I
accepted.
beg your pardon, your lordship, but they were present, at their present, and they were
Maybe-
told to
Maybe
give
if they
any
were present-
objection.
No. How can they object when there is no substantive application? What you are praying, on what ground you are praying, that is to be known to them. They have to be allowed an opportunity to controvert that. In the hearing, you will place some documents, and how can they raise an objection?
It is in the middle, your lordship, kindly appreciate that. That was, they have suppressed the fact, your
That
lordship.
you will be at liberty for enhancement. If you have, you can take out an application. In this, I will restrict the consideration only with regard to the prayers in 151. Nothing
And your
more than
lordship,
that.
and your lordship, the litigation cost, your lordship,
If you are entitled to, I will give you liberty to file an application
Grateful.
for enhancement.
grateful, your lordship.
Yes.
will do.
So now,
Your lordship.
with regard to the date of filing,
Yes, your lordship.
so what did the learned court below say?
Yes, your lordship, the court below has rejected my prayer litigation cost vis-a-vis from the date of filing, the learned trial judge did not consider that. That was in the order dated 31st of August,
With regard to
2020.
your prayer that it is to be from the date of filing of the application,
Yes,
what
your
did the
lordship.
learned trial judge say?
The learned trial judge said that from the date of order, it will be,
That
paid.
was the initial.
Yes, your
File an
lordship.
application under 151.
Yes,
What has
the
been said in that order with regard to that part?
29th of November 2024, your lordship, that is the last
29th
order which
of-
is under challenge. That is in the last page,
29th
your
of
honor.
November. Yes, what has been
Your
said
lordship.
about that from the date of filing?
No litigation cost was awarded in favor of the petitioner. That was, I have prayed before the learned judge. That is the paragraph 3, your lordship. That was, no litigation cost was awarded, and thereafter
No,
application.
modification cannot be done because you have only said from the date of the
Your
application.
lordship, I have stated
you want
miscalculation
anything more,
also.
You will be you have to file an application. They have to be given a chance to controvert that. So here, on your prayer that it is to be from the date of filing of the application, what did the learned trial judge say?
Your lordship, the learned trial judge did not consider that, and the learned trial judge said there is alternative remedies, so we need to come before the Honorable High Court. That is the observation.
Why it should not be from the date of filing of the application?
But it is not Malad, the case that everywhere where she filed application, that from the date of the application, the maintenance has to be passed. Here we have to see Malad, on what date he filed application, how many adjournment has been sought for by the parties. Now, if your lordship consider there is a judgment Malad on the similar point, but I lost because I asked for Malad from the date of the application.
Lost by justice?
Darasheko, my lord, and subsequently meet Darasheko as his lordship then was.
Oh, thankfully you have
No,
not
no,
got the,
subsequently I will.
you have not,
Your lordship has appeared in the matter. What about no Shabetta?
you have got that judgment also.
Yes, my lord, sorry. This is 2017, volume 2 CHN.
Can I have a copy, sir? Thank you.
And this has been considered. Therefore, entire record has to be brought. My lord. I will bring the order sheet. Then it will prove.
Order sheet for that records need not be brought for
Record
you have to
not, because
produce.
it's my suit.
Where is the other judgment? Other judgment you have not got. You are
Yes,
saying
yes.
that. No, no.
And kindly give me my 2 minutes, sir. Here, my lord,
Sure.
my here, my lord, kindly see, my lord, the same question came up for consideration, whether it will be from the date of the order or from the date of the filing of the application. Now, my lord, kindly see, my lord.
All right. So, can you bring the order sheets?
Yes, my lord, kindly give me 10 days time, I will. 10 days or 7 days, my lord, I will.
My lord.
All orders have not been uploaded. Yesterday, I checked up. All the orders in this case, my lord, have not been uploaded. The orders which has been uploaded.
Certified copy you have to bring.
Certified.
Why? Cannot obtain the certified copy.
Yes, yes. Kindly give me 10 days time, my lord.
In the other judgment which you will be trying to rely upon,
All the certificate copy
all
was
the
there.
certified copies
And
were.
we are learning from your lordship, my lord, because this point has been argued by your lordship, my lord. I will bring, my lord. Definitely.
My lord, one prayer, my lord. If they are taking time, kindly approve my interim order, your lordship.
What interim order?
That was the 4 lakhs per month.
Not 4
The
lakhs
distance
cannot be enhanced. It is
disposal.
to be from the
Enhanced.
date of filing or not that I will consider.
She is asking my enhancement.
Enhancement, madam, I will not consider. Enhancement, if you want, I can give you liberty to file.
Right, your lordship. Grateful, your lordship.
Ashun. $38, yes. Yeah, chapter कोणता? It is this for default. Huh? $38, yes. Yes.
I got the instruction. My client has paid that he is bringing child both the occasions, the Saturday and Sundays according to the court law. But the husband is not complying with the order of maintenance only granted to the daughter. My client having no
Maintenance I will consider. This Sunday, can you?
there was a doctor's appointment. My client even ready to postpone that appointment and to bring the child on next Sunday. But one request she has made to me that kindly ask the all areas for the daughter because my client is only bearing.
Mr. Banerjee, there is areas.
I am not in default for a single paisa. Minute I have the the calculation with me, the payment, proof of payment with me.
All right. You bring the statement showing the areas. Give it to Mr. Banerjee on the next date. Allow visitation this Sunday. Where, when?
I shall take her home. I shall again return her. For 2 hours, I shall take her.
Mr. Banerjee, what was the arrangement pad?
It was Joy Krishna Library.
So let that be done.
It is running
It's
October 2020.
It's not.
The system may be continued till the disposal of this application.
That
This is the
system
disposal of this application.
disposal I will consider this Sunday. You take her to that Mr. Banerjee's Sunday. It's open.
Sure, though. But I'm told yes.
And one more thing, I'm taking liberty. my client wants to bring her father with her also.
Maybe
Why?
this is the difficulty.
Why?
Stay outside.
Uh.
Other may stay outside.
Please don't complicate. Please don't complicate. Mr. Banerjee will also not bring anyone.
I don't. I have never.
Only the parties along with the child will come. No other person will be
And
allowed.
she should also not interfere.
Yes,
Milord,
during
our interaction.
visitation, she should remain at
At
a
a
distance, should not interfere with that visitation.
I have asked my
What is the convenient time? No, there's a doctor's appointment. Doctor's when? What time?
not said, but only said that আমার ডাক্তার অ্যাপয়েন্টমেন্ট আছে আমি পোস্টপোন করতে পারি যদি আপনি বলেন না I said kindly postpone.
There's no necessity to postpone. If there's a doctor's appointment, I think Mr. Banerjee will cooperate with that with regard to the time.
My baby, Milord.
After all, is his daughter or son?
Daughter.
So since October, my lord, every Sunday my client is bringing the child, not only for this.
All right, I am giving, since you are paying for an accommodation, I am giving you accommodation, but this Sunday,
And this matter maybe keep along with the other matter also.
what is the other matter?
Yes.
Maintenance, Milord, where litigation cost is
Maintenance, when that other matter has been fixed.
26th.
I'm fixing that on 26th of March. So
23 of.
One second, Dara, please.
So do that for these three prior to 26, these 3 Sundays. Sundays or Saturdays, which will be convenient?
Sundays.
Sunday
Milord,
will-
for at least one Sunday, kindly allow me, Milord, to take my daughter home.
Not now, Mr. Banerjee. Mr. Banerjee, I'm telling you.
She may also accompany Milord, her daughter.
Mr. Banerjee, don't invite these problems because I'm telling you, if since when you have not met with your daughter,
1.5 months.
so it may be difficult. Try with this for
Saturday, my
3 days. Thereafter, I will consider.
And Milord, VC, Milord, at least twice a week then. Milord, in addition to this, Milord, physical meeting, VC at least twice a week, 15 minutes duration. I can, so that I can.
After this, you are physically, or if you say, I can allow VC
Milord,
instead of physical.
Physically, Milord, once in a week and twice.
Let it be, because let it be for the present physical. If you have a choice with VC, I will allow VC, but not both at the same time.
Very good.
Ashun, by the Yes.
Warrant is to be, my lord, executed on Monday, my lord.
Yes. 330 resolution,
That is
you are
the-
not abiding.
Calls for another warrant, my lord.
Where is the secretary?
My lord?
Where is the secretary of the Bar Association?
আর আমি বাচ্চা
Yes, there is any caveat.
No. There's not a caveat.
Mr. Rai is leading you. Yes, Mr. Rai. Nowadays, you are not abiding the resolution of the Bar Association.
I intended to. But compelling circumstances.
Yes.
This is relating to, my lord, the custody of a minor.
Yes, yes, call the matter.
45-46.
Initially, my lord, there is a divorce. The wife categorically, by way of affidavit, disclosed that she is residing with somebody else. The mother
Why warrant?
subsequently filed an application. The girl was initially with the mother. Subsequently, an order was passed for visitation and also temporary taking the child with the father for some places. Father, after, in terms of the said order, took the child, and after that, according to the mother, she has not been returned. For execution of the same, the warrant will be issued. Now, my lord, I am only, if the paramount interest of the child is necessary, my lord, I am drawing laws to attention only 2 documents.
You are moving which application? 763.
760.
591, 760.
760. We want you know,
Important connection গুলো find out.
591 আছে 591 মানে কি টার্ন 591 ওই এফিডেভিটটা কোথায় এই যে
Yes.
if you are not
Directed to file his report if his
Yes.
assistance is sought.
yes after that my lord the
Directed to file an updated report within 1 week. Give me a minute.
yes my lord
What is the order of 31st of January?
31st of January
Where is the child now?
with the father
Why?
it was directed my lord it was remained with the father for a pretty long time that is why my lord can turn to page 8
Mr. Rai, so you have not
Page 8.
restored the custody to the mother. There was an order of 31st of January
that
2025.
was also subject matter of challenge ওটা করা হয়েছে distribution application
The other one,
yes my lord can turn to page 8 if the paramount consideration of the minor is the interest of the minor is the paramount. Then my lord can turn to paragraph page 8 and also my lord I am drawing laws to attention page 15. After these 2 documents, if my lord thinks that yes, the child can
Mr. Rai, do one thing. You serve a copy. Where is it?
Mendipur, Purva Mendipur, Purva Tomlu.
No caveat has been lodged.
Otherwise, my lord, it is my lord, can you consider 1 paragraph 8 once?
Page 8.
Paragraph 8 of
Page 8
of the application.
application, my lord, once.
591 application.
591.
Yes.
2 pages, I'll draw your lord's attention.
Yes.
This is the affidavit filed.
Page 8.
Page 8.
Yes.
Annexure A.
Self-declaration.
The self-declaration filed at the time of divorce.
Yes. Which paragraph?
Yes, my lord, can you turn to paragraph 3.
Yes.
That since 10 to the I am staying,
Yes.
living with Buddhadev, another person. Now, my lord,
When you took the custody of the
yes,
child.
হবে, date টা করবে। And now I can turn to page 15.
1-5.
Yes. This is the father of the daughter.
Page 15.
Yes, my lord.
No, page 15.
1-5, my lord.
After 13, the certified copy starts.
No, my lord is looking, my lord. 591, my lord. I am.
Oh, you are saying 591.
Yes, my lord.
591 তাহলে আরেকবার দেখি দিন page 8 টা।
Page 8. That the declaration, my lord, got it. Page 8.
Self-declaration.
Yes.
I let my husband's house at my own will. I am staying, living with such and such. Yes. No, show me by this impugned order, you are directed to hand over the child.
Child.
Show me that.
Yes. My lord, can turn to the order dated.
So this is under challenge.
Yes. This is order. ওটা কোথায় আছে?
বলছি দেখুন এই যে এটাই আছে 22/7/16/18/2 প্রত্যেকটাতে আমাকে 22 সাথে অরিজিনাল অর্ডারটা 18/16/18/2
Your lordship again turn to
So you are challenged, so you are directed to comply with on 5th of February. Why did you not move this matter, Mr. Rai, earlier?
একটা জিও ফাইল করা হয়েছিল, বাকি সার্টিফাইড কপিগুলো অ্যাভেলেবেল ছিল না।
initially it was fine. Subsequently, the certificate copy was not obtained. And with deepest of respect, my lord, with the certificate copy we have obtained, tried, but vain. That much I can say. Nothing more than that. Only if the interest of the parties to be the
Child was with you
for
since,
since
as per this declaration.
no.
No, was with you since.
আমার কাছে ডিসেম্বরে
Show me this application 24th of January,
24th.
whereby the mother paid for
Yes.
this return.
24th January. Yeah. If your lordship can turn to
Where is this petition? 24th of January 2025?
24th of January, petition is not here, the order is there. Your lordship can turn to.
You have to annex those, or you have to.
Yes, well, it is hurriedly prepared, well, it is my fault. It is my fault. I can turn to order number 14.
There was a previous order
Yes,
of 16th of January.
16th of January order. I have 16th of January, my lord.
অ্যানেক্স করে করেছি, চ্যালেঞ্জ করেছি,
ওই 16th of January orderটা কোথায়?
সার্টিফাইড কপি চ্যালেঞ্জ করেছি।
For directing the father for complying with the order,
Order.
repeated orders 16th of January, then 31st of January, you have not complied with any of the orders. What can be done?
Well,
And
this,
16th of January is also not under challenge.
হ্যাঁ চ্যালেঞ্জ
এটা আমাকে পাগল করে দিবি, জানিস তো? Yes,
16th of January চ্যালেঞ্জড।
আর 16th of January orderটা কোথায়? ইয়ে করে দিব বসে আছে। Your lordship can turn to the order dated 22nd July 2024. My lord will find everything from there.
Where is that?
Order number 14.
In which application? Order
That
number?
is application number 591,
Yes, 591. Which page?
page 30.
30.
30.
এটাও চ্যালেঞ্জ করেছি।
And
এই তো 16th of January অর্ডার, সার্টিফাইড কপি বলছি।
okay, okay. 16th of January 25 না তার আগে। Declared second passing of the order. This now proceed to pass the following order in respect to the petition for temporary interim custody of the child filed under section 12 of the Guardians and Wards Act by father of the child.
But this was on following terms. So
Yes.
this was the interim custody will remain with the mother.
Yes.
You will have a visitation right.
And
Then
also,
how did you get hold of the child?
now after that the mother is directed to give overnight access minor child only to the petitioner on weekend on the following manners.
Yes.
So she was staying with me. After that, she refused to go. After that, the child is with me. And it is not that the CWC was approached. The report of the CWC, my lord, if your lordship kindly consider.
How soon can you serve?
By within 2 or 3 days, my lord. If necessary,
আজকেই করব।
today I'll dispatch. Apart from that, on Monday I will serve a copy to the learned advocate representing the CWC.
What is the next date fixed?
Tomorrow, Monday, my lord, for the execution of the warrant.